Thank you. At this point, I would like to welcome the Assistant Director of the CPD Department, Mr. Isaac Kuloba. Thank you. Let's appreciate.
Thank you, Naserian. Our guests, our chief guests, and other guests who have been invited and are attending this conference, good morning. I would like to take this opportunity to welcome each of you, those who are here and those who have logged in online. May you feel comfortable today as we start our 4th annual conference. I would like to just introduce the subject for our conference. The school has been holding annual conferences every year, and this is in accordance with the legal mandate of the Kenya School of Law Act. Provides that the school shall hold conferences on matters relevant to the rule of law and administration of justice. So the question is, today we have the theme, Law in the Digital Age. Why did we choose this particular theme? Now, technology has become one of the most effective tools in transforming economies of the world through multiple effects on people, businesses, processes, time, and space management, amongst other things. Now, technology has become handy in solving many human problems, human needs, and has taken a front seat in driving the economy. Digital technology is now everywhere. It permeates all spheres of life, including communication, finance, engineering, economics, even democratic process. We have education, defense issues. All these things employ technology. So, but we also know that technology has its own challenges. And maybe you can say it's not really the challenges of the technology, it is our challenge in coping with technology. So, alive to the effect of technology on many aspects of the economy, this year's conference is titled, themed Law in the Digital Age. Among the issues that will be discussed, you have seen on the program, we have matters to do with regulation of digital technology. We have issues of cyber. We have issues of intellectual property. And the law takes cognizance of a number of issues. For example, digital technology is intangible. There are questions of validation of issues, validation of things, authentication of things, processes, management of data, and also the fact that technology is transnational in character, such that it is not easy to regulate something that goes beyond the boundary. So among the issues that are of concern to the law, and the government of Kenya has taken cognizance of this fact. We all know that for about a decade now, the government has been emphasizing a lot of technology in our processes, procurement processes, delivery of services, land offices, companies registry, immigration issues. All these have employed technology to varying degrees of success. So it is because of the importance of digitization that in the functioning and operation of the law that the school thought it fit to discuss this subject at this particular time. If you look at even those who have written on technology and specifically on digitization, there are some defined issues that they are grappling with. And if I may just quote one of the writers, it's a Russian writer. Let me read what he has said about law and technology. The environment of the law has been completely changed. Relationships are acquiring virtual features, and the conditions for human activity are gradually changing. The problems of determining the legal status of a virtual or electronic identity, identifying internet users, and defining automated systems have significantly arisen. The new architecture of the digital internet environment does not have the usual qualities of time and space. This sphere of horizontal network interaction has no hierarchy and subordination. The very architecture of the internet is transnational. It is associated with the construction of timeless horizontal relationships. As a result, the customary model of state and law does not fit into this form of interaction. And the problem of legal regulation of relations arising in the digital space predetermines the importance of digital issues. So I would like to welcome all of you to our 4th annual conference and wish you well in deliberating matters that are ahead of us as per the program. This is 1.5 day conference, and we hope that we are going to enjoy the various sessions, the keynote speeches, and then breakout sessions. So I want to take this opportunity to welcome the director of the Kenya School of Law to make his remarks and formally welcome you to this conference. Welcome, Director.
Thank you very much, Isaac, and good morning, everyone. On behalf of the Kenya School of Law Board of Directors, I take this opportunity to welcome you to this 4th annual conference of the Kenya School of Law. This annual conference, as you have heard from Isaac, is a part of our research mandate that we are looking to continue building and giving more prominence so that as a school, we can contribute to the development of law from a very practical perspective in this country. I am delighted to see such keen interest in the theme that has been chosen for this conference. If you look at the program, I think one challenge or one fear that organizers always have when they send out a call for papers is, what will the response be? Will we send out the call and just find that 3 or 4 people are interested, or get a wider response? And if you look at the number of papers that we are going to be seeing, then you can see that there is a great deal of interest in this particular topic from very different angles. And we're looking forward to some very good presentations. And I'm sure that they shall be of very high quality from the caliber of presenters that I have seen in that program. Some are the leading experts in this area. So as Isaac has again said, tech now permeates all spheres of life. And if we as a school are to discharge our duty effectively in training both advocates to be and the paralegals, then we have to ensure that our curriculum and what we teach incorporates the very latest technology, so that when our students go out into the world, they are well equipped with the latest positions. As you know, the school adopted e-learning when the COVID-19 pandemic arrived on these shores. And in all areas of the legal sector in Kenya, COVID-19 actually provided that spur to going online. And that has come with its own challenges, which we are finding ways to address and ensure that we are able to operate smoothly. When you look also at the challenges that have been thrown up by the digital age, there are things such as artificial intelligence, which will have a great impact on how we teach, how we practice as lawyers. In future, some of the most basic contracts which are already available online may be being drafted by artificial intelligence with a minimum input from lawyers. So where will that leave the legal profession and the legal sector? How will we cope with those particular challenges? When you look at issues related to cybercrime, I'm delighted that one of our keynote speakers from today will be touching on that topic. When you look at issues regarding evidence, criminal procedure, trial advocacy, how will we deal with the challenges that presents? There's an organization I know that a couple of weeks ago was the victim of a ransomware attack. So basically their servers were hacked, everything encrypted, and they got a message that in order to get the key to decrypt their data, they have to pay a certain amount by Bitcoin. So you can see that if you work in such an organization and that happens to you, how do you deal with that? The people who are responsible may be outside the Kenyan jurisdiction. They're asking to be paid in something that is not official currency. And the police may not have adequate capacity to deal with that. So, and if they do get the culprits, how are they going to be prosecuted in terms of the evidence that is protected? Moreover, if you're looking at data privacy, the data that might have been hacked may be very sensitive data. That raises issues of data privacy and how we take care of that. If that data is leaked to the internet, then what recourse do the subjects of that data have with regard to the organization that had that information? So if you work for such an organization, if you're going to be responsible for advising, then from a legal perspective, how do you react? So those are some of the issues that from a very practical perspective, we have to think about. And hopefully over the course of the next 2 days, we shall be getting papers, thoughts shared on how some of those can be handled. How do we ensure that the law keeps up with technological advancements? We know that often the law is playing catch up, and with the pace that things are moving and the very slow pace at which the law moves in terms of passing statutes and legislation, we may have to think of other avenues to ensure that we are able to address these issues legally. So there's a lot to ponder, and I am sure the next 2 days will provide us all with adequate opportunity to consider some of these issues. Finally, with regard to our mandate as a school and the research bit, I'm happy that last year we were able to recruit Principal Officer for Research, who shall now be in charge of ensuring that this particular mandate is discharged effectively. And one of the things I'm looking forward to, and I'm hoping that we can activate, is to start funding applied research, so that we can be issuing calls for applications. And obviously we'll be starting off with small amounts, maybe 50,000, maybe 100,000, to a researcher who will be able to present a proposal that can then be awarded. And among the conditions will be that in the next annual conference, they will present the findings of their research. Because I think that in Kenya at the moment, we have a deficit of applied legal research. There are a lot of academic papers, but we need more papers that will be looking at what is actually on the ground. So for instance, with regard to law firms, what challenges do law firms have? What sort of skills do we need from advocates? If we're talking about the judiciary, the same thing. What sort of skills do we need on the bench? What challenges are faced in terms of delays in dispensing justice? What sort of challenges are faced with regard to access to justice? I think our new research officer is going to be able to take the lead on this, prepare proposals, help us look for partners who can fund the research, and then we tap into our resource of students in the ATP and the PTP to carry out this research and then share it thereafter. So I think the future is very exciting, and delighted that all of you have chosen to come and listen to the presentations today. And with those few remarks, it is my pleasure to declare the 4th annual conference of the Kenya School of Law officially open, and welcome to all of you. Thank you.
Thank you, Director, for those remarks and for formally kicking us off. I hope that we are ready. This conference is both physical and virtual. So some of our guests will be joining online. And this morning, I'm privileged to introduce to you our chief guest, the Data Commissioner, Ms. Immaculate Kasait, who will be joining us virtually. She was not able to be here. She wanted to be here, but because of commitments, the ministry is having some meeting where they are discussing other matters. So she agreed to kindly join us on this platform. Ms. Kasait is not somebody new whom I need to introduce to you. We all know that the Data Protection Act 2019 established the Office of Data Commissioner with a huge mandate to regulate and deal with all matters to do with the data protection. So we are privileged to have her join us online. I hope she's online. And it's my pleasure to invite her to speak to us. Madam Kasait, welcome to speak to this meeting. And we hope that you'll be audible to us.
Should I go ahead? Thank you, Mr. Kuloba. I think there's no better way of picking up a conference on ICT and in a manner that we are actually addressing you using Teams, which is one of the tools that has been used largely. Allow me to, for recitals, to one acknowledge the Dr. Kibet Mutai, who is the Director, Kenya School of Law. Isaac Kuloba, who is the Assistant Director, Continuous Professional Development, CBD, and all stakeholders and delegates present. Indeed, it was not possible for me to join you in person. We are currently in what we call Connect. Connect is an annual event hosted by ICT Authority. It brings together all industry players in the ICT sector. Both, it's actually a regional conference where we get to discuss the latest innovations in IT and also some of the thought leaders. Some of the great ideas have actually emerged from Connect. One of them being the Huduma Secretariat Services, and also the Digital Cohort Program, which ICTA recruits ICT experts every year to support different departments. I hope, Dr. Mutai, next year you'll have an opportunity to send some representation to Connect. It's a great place to be, where we actually discuss every single thing as far as ICT is concerned. I feel it gives me great pleasure to join you this morning in Kenya School of Law 4th Annual Conference. I note that the participants in this conference are drawn from various institutions that interact with personal data in the course of discharging their respective mandate and duties. This year's theme, Law in the Digital Age, elicit thoughtful, provoking discussions on the respective sub-themes of law, ethics, social justice, and fundamental space, and finally, legal education in the digital age. And I think Dr. Mutai has spoken about some of these issues. We are in an era where technology is what actually moves us forward. His Excellency has been very at the forefront, talking about Kenyan Digital Superhighway as a ministry through our CS, Eliud Owalo. We are rolling out projects as far as digital transformation is concerned for the country. I am particularly glad that this conference seeks to equip the respective institutions with the understanding of the dynamics of law in the digital agenda. The conference further enlightens the institutions on the best practice and how they can, in a responsible way, process their customer data of their data. And just to touch on that, I think it's important to just underscore the issues around data protection, which is where we are coming from. It is about the centrality of the customer. And when we talk about data protection, you're called upon to reflect on what best and how best you can actually protect the rights of the data subject. Ladies and gentlemen, the digital market is being transformed at an exponential rate, fueled by the artificial intelligence enabled data processing technology development. These changes have led to innumerable innovation in the design and delivery of digital products and services, which in turn helped achieve digital access and inclusion goals, accumulating into economic growth benefits. Conversely, this innovation raised significant data privacy issues for data subjects in the digital sphere. Of particular concern are the following, and I hope these are issues we'll also discuss in the course of the 2 days. One, the data subject, that is the user, may have limited control over their personal data, or limited information may be provided or available about processing of their personal information, meaning they do not know what information you have in stock for them. 2, sensitive data may be compromised through unauthorized collection, use, or disclosure. And we've seen this happen many times, that people harvest personal data and they utilize it and they do not disclose what it is being used for. These are heightened concerns with privacy of data, which may be considered especially sensitive. For example, information about biometrics, official identifier or political beliefs or affiliation, race, ethnicity, health, or sexual identity. 3, incorrect or misleading, incomplete, or out-of-date personal data may be processed. And we've seen those kind of complaints. You have people keeping personal information for a long time, or inaccurate, they pick your information that is not about you, and those are some of the challenges. 4, automated decision making. including profiling. It may lead to unfair decisions about users, which are made on the basis of automated processing, and profiling without any human intervention may result in discrimination and unfair bias. And we've seen that conversation being discussed in different global sessions, where we say some of the artificial intelligence algorithms in artificial intelligence are normally biased and at times are inclined towards one community against another, or one region against another. So it's important that when you use personal data and use artificial intelligence, the algorithms you should also try and interpret them using human intervention to be able to make sound decisions so that you're not discriminating against the data subject. Identity fraud and misuse of digital identity may also occur. This event may result in the user financial loss and reputational damage for data subject. And we've seen identity theft happen online. And I think some of this has also been mentioned. And you'll also see there's a lot of complaint around identity theft. I think those are some of the challenges that you continue to see in the area of data protection. Data controller and data processor, system and procedures that do not have privacy policies, and hence risking in terms of how they understand what is expected of them in as far as data protection is concerned. Ladies and gentlemen, at the core of most digital investment and service is trust. The latter enables reliable and secure technology function which match with consumer expectation. The prevalence of data privacy concerns, therefore, erodes the user's trust for use in technology services. So if there is no trust, it will affect how you do your business, and it's at the center of the issues around data protection. It's important, therefore, for the delegate and regulators and policymakers to reflect and understand, one, understand the business model, partnership activities, and data processing techniques. Two, acquire appropriate organization, technology capacity, and resources. And that's important because the area of data protection is new. And therefore, without the prerequisite resource in terms of human resource and that are given to be able to ensure that the organization has the necessary resources, it becomes difficult then to become one of the companies that actually adheres to issues around data protection. Three, understanding any gaps and overlaps in the sector, for instance, in social media regulation, electronic voting technology, legal education, e-justice, e-filing, and so on and so forth. So understanding is important. Adopt self-regulation and requires innovative tools to assist in audit and investigation. We are accurately aware as an office, the space of IT is very vast, and that is why the law actually then appreciates the need for self-regulation. As an office, one of the things we are working towards is to accredit certain institutions that could help, one, in training, two, also in terms of audit, like as Central Bank has done. So that will help in terms of enhancing self-regulation in this sector. That way, we are promoting compliance and we'll make sure that everybody, the ecosystem, adheres to issues of data privacy and data protection. And establish consultation, coordinate arrangement with other government agency and private sector and civil society. The reason being, it's an area you can't work alone, you will need to work with other partners. Ladies and gentlemen, it may, for example, be considered that the data privacy rules inhibit or impose restraint on open banking services or use of certain technologies such as cloud computing. That has been the assumption. Normally, people will say data protection tend to stifle innovation. But the contrary view is that data privacy and digital inclusion are compatible goals, as data privacy rights are likely to build trust in the use of digital services. Further, Appropriate data privacy regime provides a foundation for innovation such that the digital and automation of government critical services such as e-justice, ethical academic research and use of electronic technology during election. Unregulated data practices may also work against the fundamental rights and goals of digital inclusion. Ladies and gentlemen, the right to privacy is acknowledged as a basic right under the Universal Declaration of Human Rights. Other laws and policies that govern the privacy inclusion of personal data protection are cybersecurity laws, consumer protection laws, and international best practice. In Kenya, the Data Protection Act 24 of 2019, regulation that on processing of personal data and the rights of the data subject. The provisions of the Act are well intended and far-reaching. They encompass foundational principles such as lawfulness. And when we talk about lawfulness, just reflect on why you're doing something, fairness, transparency, accuracy, confidentiality, and accountability. Perhaps just to reflect on because the conference is mostly about the regulatory framework of issues around data protection. It's important to also reflect on where we are coming from. Globally, Convention 108, which is what set pace around data protection, the framework that set pace around data protection, and then also the GDPR. The world is concerned that we have a business model called capitalism, surveillance capitalism, where personal data is collected, personal data is analyzed, personal data is monetized. If we go that route and completely focus on commercial interests and forget about the fundamental issues around the rights of the data subject, we'll have lost the plot. And that is why the data protection is there to help us reflect and actually then make the rights of the data subject as primary to what we do in everything that we undertake. For providers, a key imperative should be about ensuring that the protection of their customer data and the prevention of their privacy is not just a box that they tick, but also they comply. They must provide design, business practices, processes, and operation that keep the customer at the front. They must be driven by the rights of the customers. The fact that we have moved quickly into advancing technology does not mean we must leave the customer behind. We must make sure that their rights are safeguarded. Ladies and gentlemen, digital data handlers should therefore ensure that they comply with the established data protection framework through the following. One, by adopting the principles for data protection and data processing. That way they'll make processing data in an ethical manner. Two, adopt data protection by design and by default, meaning at the point of conceptualizing the project, they must make sure that data protection is at the center of the project implementation. Three, the need to conduct data protection impact assessment. And four, adhere to compliance in as far as data protection is concerned. Ladies and gentlemen, as I conclude, data collection is critical in terms of innovation, new tech, and data handlers must therefore strike a balance between user privacy rights and allowing the data to be used for innovation growth. And it's not unique. I have to say, I've had the experience of visiting the French Data Protection Commission, and we've seen them actually hold hackathons, or what we call innovation weeks, where they invite developers to come and actually demonstrate how they can make sure that data protection is designed in the apps that they actually develop. The data protection, ladies and gentlemen, gives us an opportunity for all of us to reflect on how best we can move and protect the rights of the data subject. This conference is therefore an opportunity for us to actually reflect, have fruitful deliberation, come up with recommendation with different stakeholders on how then we can make this issue of data protection a reality in our society today. The new horizon in the digital age is regulating, is looking, calling upon us to look into data protection. Data is the new oil, and I'm happy with that this is an issue that Kenya School of Law has taken up, and I wish you happy and good deliberation in the coming days. And I'm glad that data protection is one of the core issues you're discussing. We are available for any consultations. Thank you very much.
Thank you. Let us clap properly. Thank you. Thank you, Commissioner, for those very powerful remarks on data protection and highlighting very key issues about the concerns of data protection. We have business, we have need for efficiency, we have need for ensuring that business are innovative. But as he says, we have to also look at the data subject. We know that data is the raw material for technology. So if we manage it well, then we ought to balance the interest of the subject as well as the need for exploiting the data for economic growth and other rights of people. Thank you, Commissioner, and thank you for finding time to share with us this morning out of your busy schedule. And we really appreciate. We have picked up the points which I know will come up during the discussions in the course of this conference. It is also good to appreciate that the proceedings of this conference will be published and they'll be useful for informing policy. So thank you so much.
Thank you.
Now, thank you, Commissioner. I know you are busy. You'll be joining the rest of the team as you engage on other businesses. We wish you well for the rest of the day.
Thank you. Thank you. Appreciate it.
Thank you. At this time, I would like to invite to introduce to you the second speaker. The speaker this morning is Major David Kimemia. Major David Kimemia is a major in the Kenya Army, but currently deployed to NC4 Secretariat as Head of Critical Infrastructure Protection, that's CIIP. He has, in terms of background, he has a master's degree in artificial intelligence from the University of Bath and a bachelor's degree from JKUAT in information technology. He's coming in to speak from a perspective which I know falls within his area. We know that even defense, some of the advancements in technology in the world have been invented in the defense sector. So we would like to invite Major David to speak to us this morning on the subject that we'll be talking about. So welcome. I know that we are going to enjoy this session, and other issues will come as we discuss further after the session. Let us give him a hand as we welcome him to speak to us. Karibu.
The Director, Kenya School of Law, the Assistant Director, participants, and fellow guests. Good morning. My name is Major David Kimemia from NC4, and I'll be making this speech on behalf of Colonel Lombati, who would have been here to give this keynote speak. As I start, I'll just build on what has been discussed by Madam Kasait. And in the current world that we are in today, we find that there's an increased reliance on ICTs and connectivity, thereby promoting the social and economic development in the country. We find that this reliance on technology and ICTs has created a wide outreach to our fellow citizens, whereby you have a wide outreach of communicating to people within a very much considerable time, and also the benefits of being able to transact business online in a very much faster and easy way. Receiving and sending money now is a very easy and possible event, and this has also transformed positively on the lives of our Kenyans. And we find that through this reliance, we have the rise in the gig economy, whereby now people are able to work online from wherever part of the country, and also accessing critical services within the government and within our own country as well. And with this, we find that the government continues to promote this reliance and adoption of ICTs through the digital superhighway that has already been discussed. And we actually see that ever laying the first fiber optic cable in the year 2009, there has been tremendous growth on the reliance and adoption. And comparing that to now, we see that nearly every user, every home or organization is connected to this fiber optic or is in the process of being connected to this fiber optic. However, as we talk of the benefits of the ICT and connectivity, we do have the challenges and threats that comes with that. And one being the highly vulnerable state that our own Kenyan cyberspace is, due to the low security considerations whenever we are deploying these ICT applications and services. And we find that it presents a very favorable platform for the cyber threat actors to actually undertake their businesses in guise or without being recognized and thereby live. And this presents a challenge whereby people are affected in a way, however, they don't know the process or the procedure to approach when tackling these cyber crimes and activities. And we find that these cyber threat actors cut across state actors and non-state actors with various motivations leading from financial, economic gain, as well as acts of sabotage. And therefore, you find that the mostly targeted platforms are these critical information infrastructures that actually offer services to the citizens, among other dependents on these critical information infrastructures. And you find that most of these critical information infrastructures, they rely on the business aspect of that, however, with less or little considerations on security, and therefore presenting a challenge whereby data is exfiltrated, compromised, or in other way destroyed, or an act of sabotage. And you actually find a good starting point in addressing this is creating awareness among users on what really is cybersecurity, the crimes, and the perpetrators. And we actually see that these efforts have been since the promulgation of the Constitution in the year 2020. Other laws have been established on the land. One is what Madam Kasait has already spoken about, the Data Protection Act, and also the Computer Misuse and Cybercrimes Act, which actually establishes NC4 as a multi-agency institution to deal with these cybercrimes and activities. And we find that we're in the process of developing these regulations in order to effectively and adequately address matters cybersecurity. We also have the National Cybersecurity Strategy. All these are geared to providing a layered approach in addressing these cybersecurity issues and concerns. And we find that the Computer Misuse and Cybercrimes Act is an overarching cyber law, which aims to provide, the objective is to provide for the offenses relating to computer systems, and in there defining what exactly a computer system is, and also to enable the timely and effective detection and prohibition of further advancements of committing these cybercrimes and other related activities. And we find that it also provides for the need to cooperate both internally and externally, since this is a cross-cutting issue that requires all participants to approach it with keen and effectiveness because of the highly interconnected nature of devices and people. And therefore, you see that through that, NC4 came up, whereby it involves various stakeholders within government who are believed to be key stakeholders in tackling this. We say that the main objective or the main motivation is always for the financial gain. And in that, by selling your data, I can actually make few shillings from that, and also compromising highly protected systems that actually facilitate, enable the e-commerce or any other transaction-related activities. And we find that in this, there are key areas and actions that have been identified in tackling this, and key being among how do we have a cohesive cybersecurity governance structure whereby all these efforts are coordinated and collaborated in addressing this. Nobody can claim to say they own the cyberspace, and therefore it's always key that you bring everybody on board to address and also give their key concerns based on their sectors and have a very detailed and conclusive way of addressing this issue. And key being that is to offer protection and also the resilience. If you're not able to fully protect this, how are you able to recover in case of an attack? And also all other due processes that follow based on that attack. And this calls for the recovery measures, the law and the regulatory frameworks that we've established in order to further strengthen that. And now looking at your sector, whereby in this annual conference, the judicial and the legal sector is a very key stakeholder in implementing these regulations and laws, because you have identified who has perpetrated these acts. This is a non-Kenyan. How do you approach this? It is always back to the law to interpret on what is the best procedure in addressing this, and also provide a cautionary measure that it does not leave an open front for anybody to just exploit and undertake their activities unmonitored and leave the cyberspace. And we actually find that some of the challenges that we experience when you're dealing with this, the cybersecurity and the related activities, is you find that there's the limited capacity, and not just only to the legal profession, but to generally as a whole, in the awareness on the relevant laws and exactly what cybersecurity and crime is all about. And you find that this cuts across both the judicial, the law enforcement, and the users of these various aspects. And you see that we need to have an approach whereby if there are gaps that exist, how do we fill that in and how do you address that? The evidential challenge of how do you prove beyond a reasonable doubt that this crime was committed over a computer system, that becomes a challenge. Because the first thing when you're presenting that a crime was perpetrated, a very simple question is, what is an IP address? You have to go back and explain all these processes before arriving, and yet a serious cybercrime event has already happened. The relatively low sentences that these actors actually get and fines, and you actually comparatively to the crime committed or the financial loss vis-a-vis the fine apprehended to this perpetrator is not proportionate to that. And therefore, these are some of the things and gaps that we need to look at that. The low rate of cybercrime cases, like I said, creating awareness. Not everybody is aware that a cybercrime activity has happened. And if it does, what is the procedure to follow and how do you address that? And you actually see that even the judicial sector has adopted the e-filing platform, and soon you'll also be subjected to some of these cyber threats and activities. And if we look at that, one approach we could look from this sector is how do we establish specialized cybercrime courts? This has been successful, whereby you find the corruption and economic challenges courts has been a success within a country, and other countries are also establishing this due to the unique and dynamic nature of these cybercrime-related events. And also have the speciality to know that we have a full legal background of people who clearly understand these local cyber laws and as well as international cyber laws. And you find that it actually fosters an improved decision making, and whereby you work together as a team in order to compel and reduce these instances of cyber related activities, and also create a make a checker process that if you violate or commit these acts, then there are laws and regulations that we will have to abide to. And you find that to mitigate the challenges in prosecuting these offenses, we need to have a robust capacity building for everyone, not just the legal profession, but together collectively, we need to come through so that everybody understands from the process a crime is committed, how do you end up presenting this into a court of law, and also how do we work together in reducing this and harmonizing of laws to ensure the effective response, not just our own Kenyan laws. Kenya is now a party to other regional, the AU and international interventions, the Malabo, the UN Cybersecurity International Law, and how do we harmonize all these laws for the effective administration of these related activities within our own jurisdiction. There also the need to amend and seal these possible loopholes that these cyber threat actors exploit and live without question within our own cyberspace. And key thing being creating awareness to the public, and right from the beginning, I would say from when you begin your education process, you're able to clearly understand these aspects of cybersecurity and crimes. Countries have done that and actually progressing well. And the reason being that this cyberspace is now becoming the new preferred channel to actually aggravate your concerns compared to the kinetic warfare. It is proving to have much more gains as compared to the conventional warfare that we are used to. And in my conclusion, I would like to say that cybersecurity is actually a shared responsibility that requires all stakeholders to cooperate, both in the training and capacity building, and also creating awareness programs in our education and also to all those that we work together. Strengthening all the legal and regulatory frameworks and sharing of this information, because this is cross-cutting and sectors. These cyber threat related activities are actually unique to every sector. Your data could be of particular interest to another country, and this actually helps in shaping their foreign policies. And this is where you find more countries have stronger foreign policies among others and are better able to negotiate or have bigger advances compared to yours. And also at our own individual level, we need to also practice the cyber hygiene and to ensuring these baseline principles that we all need to apply so that collectively together we can improve on our cybersecurity posture and model in order to have a safe and trusted cyberspace for Kenya and its people. And therefore, I would take this opportunity to say that NC4 actually applauds this initiative coming from a very key stakeholder on organizing this annual conference that is themed Law in the Digital Age. This is a very critical pillar that we cannot even do or progress without. And therefore, it is actually a good initiative to see this happen. And therefore, really do count on what the output of your products rely, because that is what actually will help define the thin line between security and privacy. When you breach security, what happens? When privacy is breached, what next? And therefore, some of the, I would say, documents you do have a very big portion in addressing some of these related issues. And that is my brief speech on that. And I just want to say thank you very much for that.
Let us give Major David a proper clap. Thank you, Major, for that very concise delivery of the subject matter. As he says, maybe the next World War will be about cyber or digital issues. If US complained that somebody infiltrated the electoral system when they were doing elections, then who is safe? It's a major issue. I think we may not be seeing more tanks being made for war, but now how to outmaneuver others through technology. And I think that's what's happening even in the big five. The rest is in technology. Thank you so much. Thank you, Major, for finding time to come and share with us. It complements what the Data Commissioner is saying, talking about privacy, then the issue of security. These are major concerns in digital issues. So thank you so much, and we wish you all the best in your assignments. At this time, I would like to invite Naserian to give us guidance on the next phase before we take a break.
Please clap for Isaac. Thank you. He's been very instrumental in the organization of this conference, and we're we acknowledge the effort. This conference has been supported by various sponsors and for whom we are very grateful to. I will be introducing a few of them as the program goes on. But also note that we are also online, and we urge you, because we know you are also digital, that you take the conversation online. And when you do that, please ensure to tag us on our social media pages. Use the hashtag KSL Conference 2023 or the Digital Age Kenya. We want to see that conversation also going online so that we are able to have an impact within the theme of our conference. At this point, I'd like to invite Ms. Dana Osiemo, who is one of the conference sponsors, and she's specialized. She'll tell you more about herself, but she's specialized in legal innovations. Let's appreciate her and welcome.
Good morning. My name is Dana Osiemo, and it's my pleasure to introduce my legal technology startup to this audience. So we are a legal technology startup that's building exclusively for the African legal market, and we are developing a contract management system that automates the entire process from start to finish. So what it lets you do is from generating contracts with templates or creating the contracts up to the extent where you can execute the contract and track any termination dates and renewals. And our mission as a company is to really simplify the way you work. As we know, legal processes can be very complicated sometimes, but we want to simplify the process under a single platform to allow organizations to be more efficient, effective, and to actually save time in what they do. And on top of that, we understand that as most of you here, I can imagine, are students, and you're in KSL and the legal world, maybe you want to be a litigator or whatever it is, but the world of law is so wide, and one of the programs we're piloting is the Oslo Students Network. And so we're piloting this with one of the universities in Kenya, which allows law students to be able to understand alternative careers in law, and in this case, which is legal technology. So we link you up with organizations who deal with legal technology to either be able to do internships. We also host webinars and seminars where we teach students how to use technology, because it's very important when you come out of the legal education field to be able to understand how the world itself operates. So we give you opportunities to be able to learn different technologies such as legal automation tools, case management tools, and we put you together in a community of students interested in legal technology. And so thank you all very much for listening to this. Please feel free to come by our stand if you want to find more information about us. Thank you. Have a lovely day.
Thank you. The challenge is back to you who are interested in legal technologies. We also have other conference sponsors. We have the Cooperative Bank, the Council of Legal Education. We have Mwananchi Group. Ensure to say hi to them as we break for tea. But before that, I am sure we probably had a question or two for Major Kimemia here. Did anybody have a question to pose? And there was a 7-minute silence. All right, then. There's a question at the back, please. Just wait for the mic.
I am Chirimi Matagasia. I'm happy to be here. My question is with the result privacy as an individual. How much say do you have? Because generation and acquisition of personal data nowadays is automated. For example, if you want to use a smartphone, either you go Google way or iPhone way, and they have these terms and conditions that either you agree to them or you don't use that phone. So you do not have any bargaining power as an individual with regard to how your personal data is shared. So how can we approach as in a legislative way to address this power imbalance that exists between the data controllers and you as your personal individual?
Thank you for your question. We'll give Major an opportunity to respond.
Thank you very much for your question. This is more inclined to what the Data Protection Act provides for, that users, the data controllers and processors, the amount of information that they can be able to hold on a subject, data subject. But if I would say, normally that's a forced consent, whereby these entities thrive on this data that you're providing on. And like Madam said, that data is the new oil, and it actually helps shape, let me say 10 to 20 years in how they can customize their products and services to the consumer. And the reason why they do that is so that they can actually improve largely based on the feedback and the behavior pattern of a user. And this is where now laws are coming in, because these entities are consuming a lot of data and nobody knows what they're doing. And therefore, they are always ahead of you in the loop. They're always able to predict your next move and what you do. And actually, the consumeric behavior patterns. And that is how they're able to win you, because they know once they force you into accepting these terms and conditions, they already own you now to where you work, you live, and everything basically I can tell. And this is now where we're saying the gaps in these laws. How are you able now to address on this issue of forced consent by these entities? And how are you able to address that? And that's a new emerging area that actually needs, like I said, everybody to come on board and look at these issues and the best way to provide. Can I just buy a device that is bare and then choose the kind of operating system that I'm able to use, and how I'm able to define that as a user? But again, as well, is the first thing is you need to create that awareness to users. They are able to understand the implications and why that is happening. Thank you.
Thank you. I believe we will also get more insight as the day goes by, as the panelists and the presenters come on board. We'll definitely get more insights on the questions that we have. We will proceed for a tea break, which is being served at the left side of the ramp, meaning you can access it through the stairs that are on the left of this hall. The ladies and gents, the ladies are right under the stairs, again on the left of this building. The gents are across. You'll be able to see them. Just look across this building and you'll be able to see the gents. We also have the other ladies' facilities on that end. We will take a photo of the chief guest, the director, and the team organizing the conference, as well as the conference presenters at the front of the institution, right near the gate. So let's proceed there promptly. At this point, I want to yield my time to Okay, I'm being reminded that we are a grateful institution and would like to appreciate our chief guest at this moment, Mr. Major General Kimemia. On behalf of Colonel Evans Ombati, we have a few gifts which will be brought in at this point. Excellent. We're now free to go for our lunch, our tea break at the designated areas. And then soon after that, we are going to take exactly 30 minutes. So it's 10:30. Please be back at exactly 11 on the dot. Panelists, ensure that you come right to the front in readiness for the next session. All right. Have a wonderful tea break. Good morning once again. All right, so we are ready for the second session of the day, where we go into a panel discussion. And I hope that the discussion will help you select which theme area you're interested in so that you know where to go for the breakout sessions. I want to yield my time to Mr. Kefa Simiu, who is one of the senior lecturers in the department, in the CPD department. Karibu.
Thank you very much, colleague Naserian. As you've heard, my name is Kefa Simiu. I'm part of the CPD department here at the Kenya School of Law, where we are involved in undertaking capacity development for the public sector with specific focus in the area of law and related aspects, cross-cutting issues. So welcome to this particular session. In the next 1 hour, we have purpose to have an insight, just to get a sneak preview of what lies ahead in terms of the focus areas in this conference. And to help us discuss this session is our panelists who are seated here and whom I'm going to introduce shortly. But maybe just some bit of housekeeping. We will have an interrupted session of discussions for about 45 minutes to 1 hour. I will ask you to note the questions and the specific panelists that you would wish to direct the questions to. We will have about 20 minutes at the end of this discussion to look at some of the questions that you would have written. Now, with that, please allow me to introduce our panelists in no specific order. Please welcome Mr. Laibuta, soon to be Dr. Laibuta. Mr. Mugambi Laibuta is an advocate of the High Court of Kenya, and he has been practicing for quite some time now. Mr. Laibuta has been providing consultancy services in the area of data protection and related aspects of privacy. He has also been in academia, lecturing with specific interest in drafting, legal drafting. I'm sure some of you may have been his students. Currently, Mr. Laibuta is undertaking a PhD in the area of data protection, and I'm sure he will share some more information during his main presentation. Kindly let us welcome Mr. Laibuta with an applause. Next to Mr. Laibuta on his right is Mrs. Elizabeth Oyange Ngando. Mrs. Ngando is also an advocate of the High Court of Kenya, specializing in intellectual property law, where she, trains across 5 global locations, including Kenya, Uganda, Tanzania, and Pakistan. And presently, she manages the copyright office of Aga Khan University, which ensures compliance with copyright. Kindly let us welcome Mrs. Ngando with an applause. Next to me here is Mr. Samuel Ndaiga. Mr. Samuel Ndaiga is a lawyer, a trained lawyer from University of Nairobi, Kabarak University. He's currently undertaking his ATP training, the Kenya School of Law. But he has previously worked as an intern in the firm of Ngata and Ngata Advocates. His area of interest is in, the virtual court space, and he'll be sharing his insights during his main presentation. Kindly let us welcome Mr. Samuel. Lastly, next to Mr. Samuel, we have Dennis Emoiti. Mr. Dennis Emoiti has served as an OCS, that is Officer Commanding Station. He has also been a senior security officer at the DCI office, where he has served for 10 years. Currently, Mr. Emoiti is the Deputy Chief Protection Officer with the Witness Protection Agency, where he has been serving for the last 10 years. He has a master's in project planning and management from the University of Nairobi, and is currently a PhD candidate in the same area. Kindly let us welcome Mr. Emoit. Thank you very much. You can also clap for yourselves. I'm sure we have representation from all the classes. Thank you very much for creating time to participate in this conference and to specifically be here for this particular discussion. Now, during the morning session, our keynote addresses introduced and talked about some of the issues that the country is grappling with in the space of, ICT and data protection. I'm sure you now know that we have a conference taking place in Diani around the issue of ICT and so on. We also heard from our second keynote about the challenges that has come with this use of ICT in terms of cybercrime, and the challenges we are facing as a country in terms of how do we deal with these kind of emerging challenges. We are used to the traditional criminal justice system where parties appear in person, make their arguments, and the court, hears and makes a determination. Now, to help us just bring out these issues, we want to tie that to discussion to the current move by the government to digitalize its services. Actually, as we speak, I think the government has moved from a paltry 30 to over 200 services right now digitalized. Now, as you are aware, that will come with some of the challenges that we are likely to discuss here in this particular conference. But I just wanted to pick the panelist mind in their just a reaction on their view generally on this proposed move by the government to digitalize its services. Maybe, Laibuta, you can give us your thoughts about that move.
Thank you very much, Kefa. So the issue of digitalization, of course, is a welcome one. Kenya usually sets the pace in terms of digitization of government services. But with that, it brings about certain questions. One of the questions is whether Kenyans themselves have the digital literacy to understand how to access these services. For example, that person there in my village, and they want to apply maybe for a driving license. Do they have the technical know-how? Do they even have the devices that can access this platform? So that poses a challenge. Another thing is that also use of the internet is also fairly expensive, looking at the cost of living. So as government is doing this, of course, there are the Huduma centers that are all over the country, but not everywhere. So that brings the question. For example, from my village to the Huduma center is around 40 kilometers. So that also comes at a cost. Another question is what policy and legislative framework is available on e-government? because a lot of e-government is by legal notice. For example, if you look at e-citizen, e-citizen was established through a legal notice. The legal notice was renewed, but then still now e-citizen is still on a legal notice. So the questions that we practitioners have been having is that if you are digitizing government services, you need concrete legislative proposals or legislative, and these legislative proposals enacted to do certain things. One, what is the duty and responsibility of government? What is the duty and responsibility of the citizens? What rights do we have? Issues of cybersecurity, issue of procurement of systems, issues of dispute resolution from this, and also finally, I want to bring the issue of also marginalization. So you find if you are utilizing government services that have historically marginalized certain segment of society, if you digitalize what was happening on the physical sphere, will also appear online.
Thank you very much. I don't know what your thoughts would be, Elizabeth, in terms of trying to wrap your head around what Mugambi has shared and relating to your area of interest. What is how prepared are we, the interplay between intellectual property and the move by the government to now digitalize its services?
I actually agree with that, and particularly when you think about the north of Kenya. So most of these areas, do they even have electricity? For you to be able to access some of the services, you need your gadgets to charge. So in terms of marginalization of these communities, we need to figure out a way, in as much as we need people to apply for certain things online, is there a way that you can still retain some of that hybrid nature of these services so that people who cannot access these services can still do it the old way until we figure out how to bring them up to par with the rest of the country? In terms of intellectual property, when we think about data, we tend to think about people collecting information, particularly to do with your images. Right now, there is people who put the images online under, let's say, a Creative Commons license, and AI companies will go and take that data. They will generate and train the AI based on our images, and we're not even aware. Are there any policies that effectively address who uses our images, what they use them for, and whether we need to give explicit permissions, especially when they're being used for uses that we're not entirely sure we want to be a part of? Yeah.
Thank you very much. Very interesting questions there you ask, image rights and so on. Now, Mr. Omoit, your mandate is to protect witnesses. Now, we have these exposures. Elizabeth has just shared about the challenges around image rights in light of the government move to digitalize its services. You remember one of the challenges that has come with this is the issue of the unique personal identifier. In the previous regime, we were calling it Huduma number, but it is part and parcel of the new government move to be able to identify persons for purposes of access to these particular services. Maybe from where you sit, what are some of the challenges that portend these moves in light of your mandate?
Thank you, everybody. Maybe where I can start is that witness protection is a fundamental human right. And you find that among the justice actors, it's a critical element that facilitate investigations, prosecutions, and adjudication of cases. If you all remember the COVID-19, when it struck us, the courts shut down. There were minimal access to prisons, even the police stations. Those were serious issues. And that's when the issue of digitalization came in. We said, how do we go about it? We as an agency, what we thought is that we need to go digital. And good luck, the court started it. We had this virtual hearing. We started virtual hearing, which has come with costs, but also with other disadvantages. Because when we conduct virtual hearing, for us, most of the time you find that the defense counsel asks the witness, where is your location? Can we see you physically in that platform? And secondly, the data commissioner talked about data security and privacy. We as an agency, we are not in control of this data in that platform. These are open platforms, open systems. And maybe after this discussion, we should come with a way forward. Do we have mechanisms to control people who access these virtual hearings? Do we have mechanisms to control people who can, assuming now we do application virtually, we apply, we have a link between the witness agency and the judiciary. We apply for witness protection orders through an e-filing system. This e-filing system, we file it to a judge. We have no control of this data before, during, and after it's filed to this judge. We need to come up to have mechanisms on how we can monitor this data, on how we can even, if we are talking about the e-filing system, the witness protection agency should be given a separate link. Likewise to virtual hearing, because you go to a course list, you find the link, the virtual hearing link is provided. But we as an agency who operate in a very covert environment, very covert and confidential, to the extent that even the protectors themselves don't know the identity and the identifying information of the people his colleague is protecting. And now when you are doing this virtual application, e-filing, you give details of these witnesses. You give details and identifying information and even their locations. So it is a good way forward, but we need to rethink as practitioners. Thank you.
Thank you very much, Boyd. And you posed the question, what is the way forward? Daiga, you have an interest in the online dispute resolution space. I don't know what your view would be, just considering what Mr. Moit has shared. What are some of these challenges around, virtual court system, and what do you propose as a way forward in trying to ensure that all the interests, as has been discussed here in this panel, can actually be addressed?
Thank you. So there has been a lot of challenges with the use of virtual courts, the e-filing systems. Part of it is there has been a creation of a digital divide, in that we see that the indigent people are unable to access courts. This violates on the right of access to justice under Article 48. For instance, would look at a lady in Kibera with 2 children. This lady is out there to look for food for her children and such, but then she has a debt and she has been sued in court, and it comes to this day that she is supposed to attend court. Yes, she knows that there's court that day, but then there is difficulty in the sense that she doesn't have the devices that she could use for her to attend court. Then on the other hand, we see that the digital space is more of geared for represented clients, in that, for example, with the e-filing systems, there is quite low levels of literacy to enable, for example, that lady to be able to use the e-filing system online. Yes, the system has come with some advantages in that it enables the people out there, they can be able to follow up on their cases, but then the judiciary has not rolled out programs that could be able to educate people on how to use these programs. So in solving such issues, it would be important for instance, for the judiciary to work on improving internet connectivity in various court stations. For instance, in Machakos, there was a small claims court, then it was to be moved to another location. So upon it being moved to the new location, there were quite a lot of difficulties in that matters would start online. The small claims court had lots of matters on its course list, but then some of these matters could end up not proceeding. For example, for hearing, because there were problems in that the magistrate could not hear the parties on the other side, whereas the other parties could not hear. So the proceedings could end up being stopped, then they continue after some time. At times they have to continue physically. So we see there's a problem with internet connectivity in some court stations, which also shows that we also need pilot programs where these things are not just rolled out at once for the public to use them, but there is some steps being taken towards seeing if these things really work before putting them to effect. Thank you.
Thank you very much. I don't know whether the situation is that as bad, Mr. Laibuta. We are living in a digital age. During the morning session, some of the two keynote presenters appear to suggest that much of our interest as a country to get into this digital space and to utilize ICT in our services was influenced by the COVID pandemic. But maybe just to pick your thoughts and in order to address some of the challenges that have been brought out here, we will need legislation somehow to deal with some of these challenges. In your view, what are some of the challenges in legislating during this digital era? What are some of the generic challenges that we are likely to face in, even as we try to seal the gaps through legislation?
The challenge with digitization is we legislate after the facts. Look at, for example, Huduma Number. The Huduma Number bill came way, I think, more than a year after the government had already proposed and given us threats that if you don't register, you'll be deported. Like for me, I was ready to be deported, and I'd chosen Seychelles as my country of destination because they said, if you don't register, you're out of Kenya. Then the bill came way later. And then remember also the Data Protection Act came because of the suit that had been filed against implementation of Huduma Number. And the government said, hold on, since we love Huduma more than anything else, let us give them the Data Protection Act so that they can keep quiet. Then we had the Data Protection Act, and a Data Protection Act that has a lot of gaps. Then when we think about, for example, digitization of e-judiciary, of course, it was the COVID pandemic. Even then, practice guidelines came much later of how parties are to engage with the platform. Like my colleague Omoiti is saying, even the nuance application, for example, the Witness Protection Agency should have special consideration due to the sensitivity of the issues. Like if he's making an application in court, he should not be on the same link with Laibuta or Samuel who's making a different application, which means there's a gap. Thirdly, I talked about the issue of e-citizen. When you look at e-citizen is in place because of a legal notice that can be revoked at any time. And the proposals that have been made, I mean, we've made this proposal time and time again, is that we do require an e-government act in Kenya. For example, the US has one, Tanzania has one, Estonia has one. So the question, Kenya, with all these systems that we are putting online, how come is it we don't have an e-government act? And what will an e-government act, for example, provide for? One, it will define what are government services and what is e-government services and who can offer e-government services. It will also indicate what are the standards. For example, if you go to the Mombasa County e-payment platform, the Kiambu County and Turkana County, the standards are different. So we need standardization of services, whether it's at the national level or the county level, and to make it simplified. Another thing that we need legislation for is that who is responsible? If I have a problem with e-citizen, where do I make a complaint to? If I am if I do not have good access to electricity or internet, what do I do? Something else that legislation will deal with is who provides this platform. Is it government creating the platform or is it being created by vendors? Because if you have outside, if you have outside vendors, I think also Mr. Major Kimemia talked about it. Who are the vendors of these platforms? Because if it is private sector providing the platform from government, it raises certain questions. Who has the back end and front end access to this system? Something else is why we require legislation is the issue of marginalization. And I think Wakili talked about it, that you need to have standardization, and all Kenyans should have similar access. Something else why we need legislation is budgeting for these systems. You find that budgeting is ad hoc. It's just like, how do we budget? What the finances for these systems? Then also, we have to look at existing legislation. Is the existing legislation adequate? For example, in my research over the last 2.5 years, it indicates that certain legislation in Kenya is inadequate in protecting data in Kenya. The Data Protection Act, to a certain extent, is adequate. To a certain extent, it is inadequate. When you look at the Computer Misuse and Cybercrimes Act, to a certain extent, it's adequate. To a certain extent, it is inadequate. So the question is, one, we need to interrogate legislation that is already in place. And we've seen there's not much legislation that talks about digitization. Then secondly, we need to think about what legislation do we need to come out. Sometimes people talk about that it's over legislation, but you see, you're providing services that go to the fundamental rights and freedoms of citizens. And if you're providing any such services that go to fundamental rights and freedoms, and that you are using government funding to some of these services, there needs to be a concrete framework, and that framework needs to be through legislation. Because if it's through legal notice, tomorrow we might have a new government, and that government says we don't believe in this. But where you have concrete legislation, then it makes it harder for somebody just to wish away some of these initiatives. Just like the way it's happening in Huduma Number. Last year, who would have thought a time like now, we wouldn't be talking about Huduma Number. People thought that with the new, whatever who will have won will either continue with Huduma Number, but then we come up with a new government that says, no. For us, we are coming up with a unique personal identifier.
Which is essentially the same thing.
Potato.
Okay. Now, Elizabeth, I don't know what your take would be in view of what Mr. Laibuta has shared. It appears that our legislation is not planned, knee-jerk, not well thought out. I don't know how that then pans out in your space in intellectual property. Could we, for example, do we need this legislation? Are we copying other people? Do Kenyans or Africans really worry about IP and all these rights that we are talking about? Maybe you could just share your thoughts on that issue, and as you link up with what Mr. Laibuta said.
Okay, so I've always been curious, when you go to get government services and they take your fingerprints,
Maybe you could move your mic.
When you go to a government office and they take your fingerprints, where do these fingerprints go? Where are they stored? So I think that sometimes in our laws, it's not very clear who owns data. And I'm going to be a little bit controversial. So talking about the elections, there's always been, whenever there's an election, there's an issue was fungua server, open the servers, right? And in the last election, the issue came up about that data being the intellectual property of the vendor. Is it clear to us who actually owns data for elections? Especially when you consider that, that's Kenyan data, that's our data, that's the voters' data. But when intellectual property comes in and tells you, no, actually, because we are the vendor, because this is our system, we cannot open this server because that's our intellectual property. At what point do we then draw the line between data that belongs to citizens and intellectual property that belongs to a vendor that the taxpayer has paid for, that essentially should be giving us the data that we paid for? Okay, so it's a little bit more curious to me why citizen data is owned by a foreign company. Okay. On another issue of technology, technology becomes defunct. It needs an update. It needs somebody to be in charge of it so that there are no bugs and viruses. Cybersecurity is there. Is it clear what the role of the vendor is in safeguarding that that data within those systems? I'm not entirely sure. Perhaps we'll find out during this forum. But we do look forward to hearing about where these fingerprints go. I'm very curious, and I don't want to leave here before knowing where do fingerprints go after you put them.
Very interesting. And we are lucky that we have a Moit who has a background. I don't know whether that information is protected or privileged information. But maybe as you respond to the question posed by Elizabeth, what has been your experience in terms of legislating during this digital age in light of the sensitive mandate that you are implementing?
Of course, we have had a good and bad experience, especially when it comes to, for example, like when it say we want to go digital, most of our courts are not ready. They're not structured to that to allow digitalization. I'm just happy to note that in Kenya, maybe just 2 courts which are fully digitalized. That's the, if I'm not wrong, Kahawa courts and Shansu law courts. They are well digitalized. In terms of legislation, we have had challenges, even though we have had to overcome them. As I said, the challenges in terms of the privacy of this data and confidentiality. One of it is that when a witness joins the witness protection program, he or she is required to disassociate himself from the online platforms. But do we have a law to implement that? We don't have a law. What we are using is a memorandum of understanding, an MOU. We need a law. Yeah? That even if we can go beyond that, we are vulnerable persons, our children, young children. Can they just access any data in the open platforms, the online platforms? Those are key issues. We talk of, like in government, the witness protection agency, we don't have the case management systems. We don't have. And the cost for acquiring the infrastructure to run that system, to facilitate that digitalization is very expensive. It's very expensive.
Okay, thank you very much. I was hoping you would say something about some of the services that have been digitalized within the security space, now that you have that background. And I'm sure we have some success stories. Would you want to mention 1 or 2 and maybe share your experience?
Success stories that today you as a public, you can apply for our services online. If you go to our online, we have, in our website, we have the variable forms there, which you can download and apply online for witness protection. And 2, we can apply for protection the way I said earlier, online. And even though it has its own challenges. 3, we hear our clients virtually. And you know what? When you have virtual hearings, we save a lot. We save a lot, and also it's to save the agency the exposing that client into the area of danger. You know, most hearings happen in the area of where that incident occurred. It saves us that way. And when you also, in terms of mentally, when a witness is taken back to where the offense occurred, he's mentally disturbed. And when a witness is mentally disturbed, even his own evidence can be challenged. And if not, it means the agency has to incur more costs in terms of psychosocial counseling, psychosocial assessment, and what have you. So those are a few areas we have had the advantages of digitization.
Yes, and I think audience may wish to know that you can also apply for a certificate of good conduct virtually now through the Huduma centers, and the same can be availed.
But you know, when I'm here, I'm not speaking.
No, I just wanted to share from your previous.
My previous experience that right now you can go to Huduma Center, you apply for certificate of good conduct online. 2, even our driving licenses is online. And maybe there's the smart data device. I don't know who can answer that question. You see in I did some training. I was thinking about just to do some training in Israel. You realize that the CCTV cameras using the smart device data, they can capture the vehicle number plates, the details of the ownership, and even the driver. Maybe as a country, we also need to move towards that. And three, in the same context, we find that in Kenya, we just have doorbells. Very few people have gone towards the visual doorbells. And even those doorbells that can capture your sound so that you can know who is on by the gate. Not just that when your doorbell rings, you just go and open. We should, even as the Witness Protection Agency, that's where we are dreaming to go. Where we, instead of just physical protection of our clients in safe houses, we move where we say we offer digital surveillance. But vis-a-vis the context of privacy of this client, to what extent are we going to offer this digital surveillance? So that a protection officer where he's seated, he can at any one time know whether his client is safe or not. Thank you.
Thank you very much. You open up Pandora's box. I'm now scared that we have this concept called digital surveillance. So that even when you go to a supermarket, as you get in, the camera, the CCTV already pick your data. And then that brings the big question Elizabeth was asking. Who owns this data and how safe is the data? Okay. But from our discussions, there appears to be success stories. And with regard to access to justice, I'm sure there are certain procedural efficiencies that have come with the adoption of e-filing and generally having courts virtually. I don't know what your input would be with regard to the procedural efficiencies that come with this adoption of technology.
Okay, so part of the procedural efficiencies should be one of the fact that it's possible to handle the hearings, the court sessions without being in the physical court place. So this is efficient it reduces the cost of traveling. We see that the people from different areas don't have to travel to get to the place where the court session is happening. So in order to access justice. So that's one of the procedural efficiencies. Then the second one, as I previously said, on the e-filing system, anyone is able to go there as long as you know your case, the case number of your file, where your case is filed. For example, the court in which the case is, you are able to go there, you are able to know this matter on this date was on mention and this was what was decided. This matter is on hearing on this date. The judgment is to be delivered on this date. All that information is available there. Secondly, we also see that for the represented litigants, they are able to file documents online. So it's possible for the public and even advocates to sign up on the system and to be able to file their documents, yes, and such things.
Okay, thank you very much. Mugambi, I don't know whether you could chip in and just share your experience in terms of some of these success stories in terms of access to justice. I know you did mention some of the challenges that have come with the adoption of this approach, but what are what is your experience and what benefits have accrued so far?
For example, in my work in the counties, you find that county revenue has increased. So, I mean, that is a success story, which means that, let's say, for example, a county was raising 500 million before digitization. Now they are raising 4 billion. It means 3.5 was going somewhere. The same with, for example, e-citizen. If you look at the statistics about how much revenue the state has raised, for example, from passports, you find some it's almost 500% more. It means that money used to go. So I think that is a success story. Of course, there might be question whether what is raised is also used well, but the fact is that there's increase in revenue, and that is positive. I mean, even here at Kenya School of Law during the pandemic, there was still that argument: should we wait for the pandemic to end, or should we go online? And these classes went online, and I think one of the successes, like for example, me as a lecturer at Kenya School of Law, I think that was important in that aspect is that students could go back and look at the recording. You know, if it's a physical class, there's really no recording. It's either you were in class, you took notes, or that's it. But with going online, you find that that online class, when there is a recording, then somebody who was, for whatever reason, was not able to come to class, they can go back to the recording and take notes. So that is really a plus. Something else is that it, in terms of access to justice, is that it's opened up the courts in that litigants, you're able to track what your advocate is saying. You know, for example, if your matter, let's say, is in Kisumu and you're in Nairobi, you're able to log in online and see whether, you know, sometimes, of course, advocates, sometimes, quote unquote, they say, I've not received instruction, and we know what that means or that kind. So you can able to see whether what your advocate was saying in court and whether they represented your matter the way you wanted it. Something else is that it's also allowed for, like these days, you can receive, a judgment is made in Kisii Law Court at 10 a.m. At 2 p.m., the judgment is all over the place. I mean, and that, I think, it's about transparency and openness. If you look at Parliament, Parliament is on YouTube. You just need to go log in and see parliamentary proceedings. So there are a lot of positives in this, and the fact that there are all these Huduma centers. So as much as there are gaps, but I think if we make a comparison of our brothers and sisters across the region, I think we are doing quite well, but there's also a lot of room for improvement.
Wow. It's good that he mentions that some of the beneficiaries of this use of ICT are yourselves, actually, as students. We'll have a session to discuss that, and you may want to note some of the issues that you would wish panelists to address during that particular section. Yes, please.
As a success story at the Witness Protection Agency, you realize that since we started this issue of virtual hearing, the rate at which our clients testify has really increased. Initially, we could have a client in the program up to 3 years or more. But today, a witness comes into the program, it takes less than 3 months, he has testified, and he has let go. So in terms of saving costs, we have saved a lot. In terms of exposure, we have really, our witnesses are more secure. I think I needed to add that.
Okay. Maybe you can tie in, Elizabeth, despite all the challenges you had mentioned earlier, the issue of image rights and so on. But generally, what are some of the success stories that you can attribute to this approach in terms of IP rights online, enjoyment of IP rights online?
I think that's one of the major success stories, that majority of services have gone online. I know, for example, we at the Aga Khan University, we've been using blended learnings for the longest time. I think when I joined in 2017, I immediately had to start training online. So one of the issues that tends to rise out of this is image rights. So when you're attending a webinar or a meeting and all of a sudden you see recording in progress, do you jump? Did somebody ask you for permission whether it's okay to record you? When you come to a forum like this and there's a photographer going around with a camera and they're taking your pictures, where are those pictures going? I think we've seen cases of late where people have successfully sued universities because their images have been used in ways that they didn't approve of. As a matter of fact, we all have a right to control where our image is used. And if you're just giving your images because perhaps you're being told to, but you're not questioning how are these images going to be used, then you need to be aware that you have a right in law to protect how your image is used. And in countries like the UK, where they have all this facial recognition software, I think there was a bit of a furor a while back because it turned out that the police were actually collecting images of people so that when you walk along the street and they can detect that you're a criminal, they pull you to the side and they question you further. We're not there yet, but you can essentially see where this is likely to go, where your data is being collected for no apparent reason, but along the way, if you look like a criminal or you have a criminal record, then you can be flagged down. And another one that usually gets me is this census data. So it's very important that the data is collected. It's important for a country. But when you give out all data to somebody who particularly don't know how it's going to use that data, how many phones do you have? You have 3 TVs, you have 4 cars. This person could be coming to visit you next week. Where is this data going? Why so much personal data in the hands of people who perhaps don't quite know how to handle that sensitive data? Yeah.
Wow, thank you very much. And to just add on what you have said, government policy now requires procuring entities to publish names of, to have to have names of the service providers, right, on their websites, and people they have entered into with contracts for supply of various services. So those are some of the challenges. But just to now get some kind of feedback from you through your questions, we have 10 minutes to go, and I would like us now to field the questions that you have been noting, and please indicate the panelists to whom the question you want to respond. If you are not able, then I'll be able to pick them and direct them accordingly. Let's have questions from this side. Yes. None from this side? Yes. There's a hand here. Mike, please. Just give.
I am Newton Chirimi. I'm happy to be here. I have a question and a point that I need clarification on. The question is just general. With the digitization of government services, you find that the payment system, the single source people that you pay. For example, if I can give the example of General Post Office, if you go to the GPO, any service that you want to access over there that needs you to pay, you must pay via KCB Bank. So I am wondering how that your freedom of contract as a free citizen, it seems like the government is compelling you to contract with third parties that you have no interest in contacting with. Even if you're trying to renew your license online, usually they'll tell you must pay with M-Pesa. So what is the implication of that? The government compelling you to contract with third parties. And then with the issue of clarification, it is to Madam about the opening of the servers, because it might be my erroneous understanding. The reason they refused to open the servers was because opening them would how they tabulate the data and how the algorithms and whatnot. That is how people voted is an issue of public record. So the data of how people voted was an issue of public record, but they contended that opening the servers would put their algorithms and how they process the data at risk. So it was not the data in as of itself that was the issue. It was how the data was tabulated that they refused to open the servers for such reasons. Thank you.
Take one more and then we can respond.
Okay, thank you. Kuloba is my name, and thank you panelists for discussing those very important points on the digitization. My question is on Article 6 of the Constitution, and I think this one is Mr. Laibuta will directed to him. In your view, should the government charge what is called convenience fee for using eCitizen and I think e-filing also there is some fee which is called convenience fee. Does it mean they don't want people to have that convenience? If you want it, you must pay for it. This is because Article 6 expects that a national state organ should ensure that its services are available to the people as much as possible. Now, you have paid fees for those services, then you pay more. What is the role? Who fixed this amount, and how? What about public participation, like in other areas where people are supposed to contribute before they are subjected to a particular law? Thank you.
I think we can take the two. Mr. Laibuta, you will take the one that has been directed to you, but also add what our colleague there mentioned, the issue of being required to pay to specific service providers. And then Elizabeth, I think you can respond to his concerns with regard to the data issue.
Now,
Yes.
so the proposals that we've made, I've made this personally and also as a group of professionals, is that, an e-government statute needs to have several provisions. Some of the provisions has to do with procurement processes. If, for example, government is procuring a third party for a payment platform, the one of the important factor is that it has to have gone through the government procurement system under the Public Procurement and Disposal Act. Then secondly, procurement of digital services needs another level of inquiry, because you see, when you're doing public procurement for different services, whether it's engineering, etc., there's usually a set of questions or a set of, there's a checklist about whether this vendor has met, whether this vendor is certified, whether they have a tax compliance certificate, etc. Now, in procurement of digital services, whether in government or private sector, if you what we call vendor assessment, you have to assess your vendors. And when you're assessing your vendors, there are certain questions that you ask yourself. One, what is the level of compliance of this vendor with provision of, let's say, the Data Protection Act, cybersecurity laws, etc.? To what extent are people working with this vendor sensitized about the provisions of this law? Does this vendor have policies, procedures, and standards in place for purposes of cybersecurity, data protection, etc.? Does this vendor have personnel who are well trained and understand? So when you put these provisions and this checklist within the law, then it will address some of those questions that if it's KCB, if it's Safaricom, if it's cooperative, whatever it is, then you'll know they meet the criteria that is set in the law. Similar to what Mr. Kuloba is asking about the charging of convenience fee and public participation, you find that what will be appropriate is that instead of these fees being ad hoc, then they should come in within regulations or legal notices within the act. So that's say we are providing we are providing government services, but through legal notices, through regulations, we shall set the parameters of how much needs to be paid. And of course, if you're doing subsidiary legislation, it has to be subjected to public procurement processes. But now, as it is, the amount you pay in some of those services online, it is ad hoc. Of course, some of them in the counties, it's there in their Finance Act. If you go to the Finance Act, you'll find that the amount you pay to the market, let's say you're paying to Karen Market or Kajiado Market, might be under the Finance Act of that county. But you'll find in certain services that just emerge, then somebody just decides, okay, for access of this, people will be paying 1,000 shillings. Then you ask, for you, in public procurement, when you're under the Constitution, when you're raising revenue or using public money, it must go through that process. And I think what you raised, it's a gap. But if we had an e-government law, then it will perhaps address some of those. And it will also set standards. What maximum can you charge and what minimum can you charge, depending on the kind of services that you are accessing.
Yes, thank you for that response. You raise a lot of questions again. And I like it that you pinpoint a potential gap actually for law reform, legal reform, e-government law, and so on. Yes, Elizabeth, your reaction to the concern?
Yes, so on the issue of the servers, so there were many issues and reasons why they couldn't open the servers, but the one I picked out
to do with intellectual property was because of the data part. So I understand perhaps they wanted to protect the algorithm, which is within the right because that's intellectual property. You don't want people to know how you do your business, and that's fine. But my interjection was to do with the intellectual property of the data that Kenyans posted on it. So that's one aspect, but it's not the full reason why they shouldn't have opened it. I was just giving the IP aspect of it.
Okay, well enough. Let's move here, the center. Let's have at least 2 questions. There's a hand behind there in white. And then maybe you can start here. We'll come to this side. There are 3 hands there. So 1, 2, 3, and then we'll come to this side.
My name is Cornelius Lupao. I wanted a clarification on what Madam has just answered my earlier person who asked that question on intellectual property vis-a-vis data. The data that was put in that server belongs to Kenyans. If I'm voting, my expression is mine. If the data is mine, how does the person storing or transmitting or working around that data, which is supposed to be primarily my data, again have a claim from that person as having intellectual property to it?
Okay, you note that. There is the gentleman in the suit there.
Good afternoon. My name is Tali Israel Tali. I have several questions. First is to Mr. Laibuta. I'm interested and I applaud the suggestion for the e-government law. My concern is whether that law, the scope of that law, can be consolidated into what was then to be the Huduma Number Act, so that we have our laws consolidated into one for easy over access and synchronization. And then the second question is to any or all of the panelists. So with respect to access to justice in the digital space, whether we have had any empirical and scientific survey that has been done to establish the real impacts of access to justice on the ground. Because when you hear of people at industrial area, for instance, many of them will tell you of their experiences, how their matters will be called. They don't have representations. They will not understand what is happening. So do we have an empirical survey that has been done, or should that be one of the recommendations from this conference to commission an empirical survey to exactly establish how far access to justice has gone in the digital age? The third one is to our good self from the Witness Protection Agency. I'm more interested in security of individuals and witnesses. And first, there was an interesting suggestion on whether CCTV cameras that are mounted on our roads in supermarkets, whether they amount to surveillance. I'd want to understand about that, whether the fact that when you go to a supermarket and a CCTV camera captures you, you go to the road, it captures you, it's very easy for somebody to predict your pattern. So does that amount to surveillance? If yes, what is the framework around that to ensure that such data captured by such private entities is not retained that can cause harm? Now, with respect to now witness protection, I'm interested to understand whether digitization has made witness protection more difficult, or more it has protected witnesses more, considering that in the digital age, I believe it will be easier. It will be easier, let us say, for somebody to hack into a system and be able to predict a pattern and to able to find out the structures put around witness protection. And then still on witness protection, with respect to collaboration, with other agencies. As you might note, recently the Office of Director of Public Prosecution launched the interagency guidelines on collaboration and cooperation among security agencies. Guideline 12 is on witness protection, and it requires the agency to liaise with the Witness Protection Agency to liaise with other agencies such as ATPU and the ODPP to identify vulnerable witnesses and put up measures for their protection. So I want to understand whether this collaboration and cooperation is something that the agency will welcome, or witness protection is a matter solely for the agency, again, because of security concern. And then finally, still on witness protection, is with respect to in-court protective measures, such as, let's say, voice distortions and concealing of the witnesses that are testifying, like we see in Kahawa law courts. I would want to understand the weight of such evidence and the effect such evidence has on the rights of the accused, considering that you do not get a chance to know the witness, and so you might not know if somebody is making up a story. So what is the weight that is given to such? I think for now, I'll leave it at that. Thank you.
Yeah, now I don't know whether we can take those first before we come to you. Up, you don't have many. Just give him so that we can close this side. And as we do that, yes, we have some online questions. We'll come to you last, so please hold on. We'll give you an opportunity for those who are following us online to ask your questions. Yes, please.
Good afternoon. My name is Eugene Akumu, and my question is on the interface between intellectual property law and the move towards digitalization. And I would like to make reference to a recent development in artificial intelligence, where now you find that third parties can appropriate the voices of artists to actually create songs using artificial intelligence. And the position is that copyright does not recognize a voice as a subject to something that can be copyrighted. What's actually recognized is the recording of such a voice. So now you find that such artists, when their voices are appropriated using artificial intelligence, they don't have a remedy in law per se. So my question, or I'd actually want to hear the opinion of the panel on the fact that I resonate with the fact that for actually this to be remedied, then the laws governing data protection, copyright laws, they have to be formulated in a way that they are so flexible to actually cover such gaps that might arise because you find that the controllers of data, they seem to be ahead of us. So now I wanted to hear your opinion on the flexibility of the law in handling such matters, because I feel like when the law is much more flexible, then we'll be ahead of the controllers of online data. That's my question. Thank you.
Okay, thank you very much. So we will start from there. You can address us. I think there were two questions. You can start with the last one, the interplay between intellectual property and...
Okay.
Yes.
So in terms of copyright, the law recognizes anything that's created by a human being within a creative space. So as soon as your pen leaves that paper and you're a human being, the law will recognize it. Now, in terms of AI that generates voice, the law doesn't cover anything that's created by AI. So an AI, as of date, in most laws, cannot be a copyright owner or have any copyright protection for whatever it's created. So images, voice, and perhaps that's why you're saying that cannot be covered under copyright. Yeah. So for now, there's still discussions on whether the person who created the AI should be the owner, or the person who bought the AI software to create the work should be the copyright owner. But for now, there's still a gap in the law. Yeah. And on the issue of the gentleman who asked about the data. So I began by saying who really owns data? Okay, so if I take my phone and I take a picture of everyone here and your faces are all data, that picture is mine. I can do whatever I want with that data. And if I take your phone and I take a picture of you on your phone and you keep your phone, that picture is still mine because I'm the one picture. So I own that picture in the same essence that whoever created that election software that captures all that data owns that data. And so perhaps policy needs to consider elections is a national phenomenon, and certain exceptions will allow us to be able to get somebody to release that data when we want it, because that's our data. It's for a certain exercise. We are paying you to conduct this exercise for us. So essentially, we should have the rights to that data. Yeah. But in copyright law and intellectual property, whoever creates or owns the contraption that keeps the data is the one who is the only person who can control it. Yeah. So I was just suggesting perhaps a policy that makes exceptions to an exercise like elections to allow people to be able to access that data, because we are paying you for that practice and that exercise. So we should be able to see that data under those exceptional circumstances.
Okay. Maybe Laibuta can go first and then.
So let me talk about data that is, somebody talked about CCTV elections data. So when you look at the Data Protection Act, Section 25 provides for data protection principles. Some of the principles is that data has to be processed transparently, openly. It should be free from discrimination. It should pay attention to certain things like the security of the data, informing people what you're going to use the data for, etc. When you look at Section 26 of the Data Protection Act, it provides for rights of a data subject. So under Section 26, you and I, as data subject, we have a right to be informed what our data is going to be used for. Secondly, we have a right to access that data. We have a right to correction of that data. We have a right to deletion of data. But then, in data protection laws, which is not clear, which are some of the gaps in our data protection laws, it is not clear when particular points where such data protection principles or the provisions of the data subject rights will not apply. For example, the Data Protection Act under Section 51 provides for exemptions of the Act on what it calls national security and public interest. But our Data Protection Act does not define what is national security and public interest. And we know in Kenya, this can be swung to be anything. We can say getting into Kenya School of Law is a national security issue, but there are no specific guidelines on what that is. So what we require is, for example, in last year, the Office of the Data Protection Commissioner and the IEBC came up with guidelines on data protection. But from the conversation here, I think this needs to be fleshed out and to be specific, that go even to amendments of provisions of the Elections Act. For example, under the Elections Act, you and I have access to the elections register for obvious reasons, because if you're carrying out an election, the register must be credible, it must be verifiable. Same way goes to election results. They must be credible. You should be able to verify if somebody got one vote. You should be able to go and say, yes, it's true. This person got one vote. But of course, not to say who voted. So another gap that is there in our systems is about management of public databases. Because in Kenya, we have different databases. We have the elections database with the integration populations register. We have NTSA data that has our data. We have, so there are a lot of databases in Kenya, but some of the challenges are this. We do not have regulations that are specific on who accesses these databases and why should they have access, and who shares data out of these databases. What is the issues of transparency, security, etc. from these databases? Because at some point, there are also databases that are public record. For example, the filing systems of the judiciary. Apart, of course, for example, where it's children's cases, sexual offenses, etc., there is very specific. So the question is, in all these databases, what we need is a very clear policy guideline that is couched in legislation that says, if there is a public database, if it is a database in elections, what data should be accessible, what data should not be accessible, and why? For example, the algorithm of the election system service provider might not be accessible, but the data in there. The question is, to what extent should it be available? And I think one question also that we need to answer, what does it mean to open the server? And what access, what do we mean about access? Now, on something else that somebody asked about the scope of e-government and Huduma number law, of course, we have to make a distinction between, all these are fundamental rights. For example, your right to identity is a right under the Constitution. And we've had laws on identity, on registration of persons for long. We have registration of persons, registration of deaths, we have citizen management, etc., etc. And this is very different from e-government. E-government laws, when you look at across the world, they specifically say they are couched in general terms. If the government wants to provide a service digitally, what principles, what framework should apply, and that will be the distinction. The e-government law will also set standards. If a government is putting up services online, and in some countries there are different layers of government. As we are only two, we have national government and county government. That if you're accessing e-gov services in Turkana, it should not be different from accessing NTSA services. The standards should be the same. I think that covers what.
Now, Mr. Moit will come last because yours were fairly heavy. The lawyers here will respond once he has done on the evidentiary value of this distorted voice. I had something like that. What evidentiary value, if any, does that kind of is it? Okay, you will take it, but maybe after he has responded, there was a question which was directed to you, but which, because he has an interest in the area, he can partially answer it, and then you'll also respond to it. I think one of the participants here asked a question touching on access to justice and wanted to know whether there has been any empirical study or scientific study on the impact of these, virtual hearings, e-filing, and so on.
Okay, I would say there is no. I've not found any specific study, but then there are studies that could guide in assessing how the use of online dispute resolution mechanisms has enabled or disabled access to justice. For example, there was the KNBS report in 2019. It was part of the petitioner's argument in the Legal Advice Center, Trading as Kituo cha Sheria versus Chief Justice and two others, 2021. The argument was that it's only 15% of, pursuant to that report, 15% of the Kenyan population that has devices that could be able to, that could enable them be able to access online courts and the e-filing platforms. Yes.
Of the gaps, and we wish maybe when you do your presentation, consider shining some light there and see whether it's a potential area where a gap exists to be looked at, so that when we make a case for this approach, then we have some data backing that. Thank you very much. Now, Omoit, I think you'll take the bulk of the questions remaining. There are now 4 of them directed to you.
Okay.
Yes, please.
Maybe I start with from the evidential value of distorted evidence. First and foremost, there's no distorted evidence. Your individual right and vis-a-vis fair trial and access to justice. When we are talking about your individual rights, we are also talking in terms of fair justice, fair access to justice. This person has been threatened. Why is he placed into the program? Because of being threatened and intimidated to testify. That alone breached that. That what do we call it? It outshines your access to your rights to fair trial. But you see, maybe our lawyers could have helped me here. Your right to access justice outshines your individual rights. I think that's the best way to put it. Yes. And it's a balance that we find the voice is distorted, but the information is the same. It's very accurate. And the court has verified that the person speaking is the witness. That's why we go to High Court to obtain these protection orders. We don't just come to court and have this voice distortion presented before. They are being tested at the High Court. Two, we talk of digitization at the witness protection. You see, it has created more opportunities for linkages, especially in terms of processes between the justice actors, the criminal justice actors. Like now, the agency has an e-filing account with the judiciary. With ODPP, we are linked to ODPP. We are working as a multi-agency team, similarly to the National Police Service, although they don't have a digital platform. Virtual hearing has created a safe space for our clients. They can testify in the comfort where, away from the danger areas. Virtual hearing has created, has facilitated speedy disposal for our cases. As I told you earlier, most of our cases today for protected witnesses have been disposed of faster than they were before. In terms of the security and of the data and what have you, you see our processes that have been filed in court through the e-filing system, these processes and the proceedings are more accurate. And in terms of the documentation we have today, we have more accurate and verifiable documentation today using the digitization processes. Efficiency has seen, today we can file this thing online and even serve our defense counsel online immediately, simultaneously. And we can simultaneously receive notification from the judiciary that they have received our filings. In terms of maybe the last one now, we talked of the multi-agency approach in among the justice actor system. That approach is lauded for, is good, and we have been doing it. What we are doing now is trying to document what we are doing, because we find that the agency is a referral authority. We depend on referrals mostly, because if you look at our data of application we received, most of them are from referral, from the ODPP, from the National Police Service, from the judiciary. So you find we have to get a working, to document our working relationships, so that in terms, if you look at that rule, you say that identification of witnesses. Not only that, if you read it that way, you miss the point. Once we have identified, we have rigorous processes of what we call, later we will take you through what we call risk assessment processes within the agency, so that at the end of the day, the Director of Witness Protection Agency has the sole right of admission into the Witness Protection Program. I don't know if I've answered those questions.
Yes, you have. Save for one, as a limp, I think one of the participants here, audience members, asked whether the data that is captured on our roads and in the supermarket would qualify to be defined as surveillance. And if yes, is there a legal framework for handling that data? I know Mr. Laibuta mentioned that one of the exemptions to the data provided in the Data Protection Act is for, those security. But is there a legal framework for? Is that surveillance, and is there a legal framework, or there is a gap?
It's surveillance, yes or no? But to me, from my background of security, that is surveillance, because it can be used in the court of law as circumstantial evidence. If it's produced, it can be verified that this data was gotten from that CCTV and it happened. You can be taken to court. We have seen cases of late, people using that data to take people to court. Maybe my legal colleagues have different views.
Yeah.
You see, as he says, under the Evidence Act, you can adduce electronic evidence, like the certificate of origin, the affidavit that needs to be sworn, etc. But then the gap that was there, so there was a time the Ministry of Interior had a CCTV policy in draft. I think it disappeared. It disappeared somewhere. I don't know what happened to it, because what some of the gaps that we have is that to what extent should, for example, police have to access CCTV, maybe in my house, or CCTV at a supermarket or at a mall, etc. That gap is there. But you find that if you're carrying out surveillance, different laws, and I think Mr. Mohiti is better placed to say this because he might have done it practically. There are very clear guidelines on this kind of evidence. For example, communication surveillance specifically, CCTV may not be communication, but it's communication surveillance and the different laws, including the anti-terror laws, is that first you have to seek authorization from Inspector General of Police, and you have to get a warrant from the courts. Of course, sometimes practically you find that the officers will take shortcuts and just go and say, give us this data, etc. But the question is, will that evidence be able to be produced in court? Because there will be gaps in terms of the procedure. Then something else is that CCTV policies within our institutions. For example, if you're in an institution under data protection compliance, even an institution that has CCTV, there ought to be a CCTV policy. And a CCTV policy ought to indicate certain things. One, you need to inform people that you're entering a zone that has CCTV. Secondly, you need to inform people, what are you using that CCTV for? Is it for security, etc., so that people are well informed. Then you also need to tell people what are their rights in terms of this CCTV. One, for example, they could have a right to access if there is the footage that relates to them, they could have access. They have a right to deletion or correction of any false or misleading data. But I don't know how CCTV coverage could be false or that. Because, for example, I think you've heard of these cases where you're at a club and maybe you're a pastor or an imam, and a photo is taken of you dancing and twerking, and it's put in a social media pages. Then the question comes, I mean, I'm an elder of the church and you put my photo there down in shots of this or that and gyrating. So those are some of the, I mean, it's work in progress, but it's within that system. If you have CCTV, if you have people taking photos, to what extent, what is your right, you as a data subject, and what are their duties and responsibilities? How do they keep this information safe? For example, every other day we see online, people are sharing clips of CCTVs that in the estates, maybe an incident has happened and all of a sudden, somebody in that premises takes a clip and shares it online. The question is, what should be the repercussions if they have shared that information without following laid down procedures?
You see, we are getting into the very dangerous zone, but it's good that we are asking ourselves this question so that we are able to provide for, whether laws or policies that will be able to guide that particular space. Let us now pick questions. I can see 1, 2, 3, 4 hands here for now, and then we'll come back. You can start from the gentleman there, then this.
I'm Victor Ngunjiri, and my question will be directed to the lady with regards to how she's interpreted the situation with regards to the server and the contents that are in server. It brings a very murky issue because now you see, as Mr. Laibota has said, and even the courts have interpreted that our data with regards to electoral processes, for instance, in the case of ODM versus IEBC 2019, that the data that the IEBC has should be open to people to see for purposes of verification. And now when you say that this and with regards to our right to information, and that where they say that information should be open to the public, and where it is not open to the public, that's the exception. So when you say that this data, our data that we've given to this person who is handling the IBC data, is their property, and now us accessing it is more of a favor from them than a right, don't you think that your position is contrary to what the courts have held, that information to do with elections and maybe our data should be open for purposes of accountability? Because now we don't know what is there, but that's our data in as much as they are the ones who have it.
Okay, thank you. Now, maybe just as a guide, because of time, we may not take many questions. These presenters are still here with us. If you have specific questions relating to an area that is already in our program, maybe you can save that for that particular session so that you only ask questions with regard to what the panel has discussed. Yes, you can.
Good afternoon, everyone. My name is Mungai Jackson Kibe. My question goes to my learned friend and colleague, Mr. Samuel Ndaiga. Is there a restriction or a limitation on the kind of evidence that can be submitted in a virtual court session?
Precise. Yes. There was another hand. There were four. The gentleman behind you there. We'll come to you after him. Yes.
Yeah, so my name is Brian Okot. My question is, I have a question and a concern. The first one is, there is the issue of ethical hacking, and it came about during the last elections when, Honorable Raila came out and said they ethically hacked, and now they have their own results. And there was the issue of, it was an emotive issue where people said, you can't appropriate and reprobate and say that the systems were hacked, and then you come and say that you ethically hacked the system, and now you have your answer. So what is the place of ethical hacking in Kenya? The concern, I think, I'm also wondering, together with Ms. Oyange and 1,000 others, that when it comes to election data, and the company that was given the tender says now they have, intellectual property over the data, it raises concerns over data hostaging and also data trading, and it's data that belongs to the citizens, and the company here comes in as a third party. They only facilitate the elections, and so could it be a case of data hostaging that we want you to open the servers and let us confirm certain things, but you come and say that you have intellectual property over the algorithms and whatnot? And also, could it, or how prone is it to data trading, where you say the company might decide that it's our IP and we can sell it to someone else, a third entity, and such like things? Thank you.
Okay. Now the good lady there, we can take one more there, and then we can have the response.
My question is directed to Mr. Samuel Ndaiga. In terms of virtual courts, you have talked about the indigent person. You have seen that there are very many instances where lawyers are tweet in Twitter and say that they're in court and they say, I can't hear you, my lord, I can't see you, my lord, yet they're next to their neighbors. So their neighbors keep wondering, why is this lawyer talking directly to the Lord Jesus? So what criteria are you proposing in terms of the use of online courts or the virtual court system? Should we continue using them, or should we adopt a hybrid system?
Okay, we will start from here. Samuel, what's the way forward?
Okay, so I'll start with the first question by Jackson. He asks if there are restrictions as to evidence that can be submitted in a virtual court. And I think, yes, there are. You can't give real evidence in a virtual court. It has to be in a physical setting. And further to that, I also think there are limitations in the sense that in a virtual court hearing, it could be a bit difficult for the adjudicator to tell the demeanor of the witness, which in most cases is usually an important ingredient in the administration of justice. And to the second question on whether we should adopt a hybrid system or remain online, I think it would be good that we adopt a hybrid system, in that the online system, it has brought some or lots of benefits, but then there are challenges which are majorly being faced by these indigent people. So having a hybrid system would be something good, because it would benefit both ends, in that the indigent person can come to court physically, the other counsel can still continue continue representing their client through the virtual means, just as is happening here, where some people are viewing this session online and we are here physically. So a hybrid system would be good.
Okay. Now, there were a number of questions that were general questions. I think the server question, we can spare it for an appropriate session. Maybe we can have or you want to open the server?
The problem is that we politicize things and politicians never think ahead. Because, for example, before the elections, there will have been questions. What does the contract between the service provider and IEBC say? Because there have been a lot of questions about procurement of elections technology. And ideally, the contracts, the duties and obligations of all parties should be laid bare, especially to Kenyans. For example, what are the duties and obligations of the service provider? To what extent where do they store the data? Because another question that, the Data Protection Act provides that if you are dealing with personal data for election processes, it should be stored in a server in Kenya, or a copy should be kept in Kenya. Up to now, I don't think there's anybody who's asked that question. Whether this service provider and this election data, it was stored in Kenya, or there's a copy stored in Kenya. So I think for the political actors, I think moving forward, they should be asking these questions. What does the contract say? What are their duties and obligations? The question of access, who will have access and to what point? Will they, for example, the question, would litigants have access to the algorithm of the service provider, or will they just have access to the data flow? These are different things. And unfortunately, I think because of the emotive nature, because when you mention servers, there are people who are happy they won, there are people who are sad that they lost. But the technical fundamental questions are not being asked, because there's also the question of ethical hacking. Ethical hacking, if you're doing cybersecurity compliance, there's what you call penetration testing. And ethical, where you check whether systems have vulnerability, so that what you do, you harden the system, you patch the systems where there are risk and vulnerabilities. And you see, these are conversations I think we are not having, because we are more interested in who won or who did not win. But moving forward, I think within the electoral system, especially the contractual, the duties, obligations, the issues of penetration testing, etc., are very key.
Maybe you can deal with the data hostaging as you respond to the other one.
Okay, yeah, I just wanted to add on to what Mugambi has said. So, yes, in terms of those, there's usually an intellectual property clause in those agreements that specifically outlines who owns what and what you can do with that data. And in terms of the ethical hacking, companies will have policies on what you can access that's stored on their servers. So, for example, I think there was a case where they needed to use some evidence on somebody's WhatsApp account. And WhatsApp is encrypted. And they went to WhatsApp and WhatsApp said, no, as a policy, we don't release data because that's the core of our business. Our conversations between the people who use those are private. And I think there was also another case where the police were trying to break into someone's iPhone and they went to Apple and Apple said, no, as a policy, we don't release that data. That data is only between the person who put it there and, if need be, Apple. So it also depends on the policy of the company that holds the data. And sometimes there's nothing that you can do to compel them to release it.
Thank you very much. We'll have one question from online, and then we'll take one question from this side. I know there were other hands here. We will see how to accommodate you.
Thank you. This is a list of questions coming from the Teams account. The first question is, with the rise of deepfakes, what does that mean for our picture, stroke sound, stroke video evidence? Second question is, with CCTV manipulation, what is the way forward with regards to virtual courts? The third question, with regards to e-filing, who is the data controller? Fourth question, there has been cases of Safaricom leaking out customers' data to strangers, and maybe you find an M-Pesa account is hacked or the person's data is used for criminal matters. How is that being handled, since it's very rampant? Then fifthly, in the case where pictures are taken of you while attending an event, and the same are circulated via social media of the entity that held the event, is there any claim of image rights or breach of Data Protection Act in as far as image is concerned? She gives a scenario. Supposing I would have preferred that people are not aware of my attending the event. What about where my image is captured erroneously by an influencer recording her or himself, but is shared on social media? What are my rights?
Open, I think any of us can dig in.
Okay, I have the mic. So in terms of providing provision of judicial services, I would say the judiciary is the controller, because when you look at Section 2, the controller is the person who decides, the person or institution who decides the purpose for which data is going to be used. So the judiciary, I mean, within the judicial system, practice order, practice directions, etc., the various rules of procedure, it's very clear what data litigants need to provide. So if the judiciary is saying you need to for us to provide you the judicial service, you need to provide to us the following data. So to that extent, you can say the judiciary is a data controller for purposes of provision of the judicial services. However, you can go further and go to the advocate-client relationship. So here you'll find that the client will be the client could instruct the advocate to act on their behalf to a certain way. Where, for example, the advocate is acting as an agent, where there's a principal-agent relationship, then you find that the client is the controller. But the advocate could also be a controller to the extent that they tell the client that you need to provide to us certain elements of data for us to be able to represent you. So as you see, it is a very murky, it depends. If you're to determine a controller, you have to make an inquiry. What is the duty and obligation of each parties? Then I think there's another issue about these pictures being taken at events. So this has both a privacy and an IP angle. So you'll find that the courts these days have taken image rights to be a privacy issue, an Article 31 issue. They don't really argue it out as even as me as a privacy practitioner, as we usually say, image right is a privacy issue, but IP lawyers will have a different thought to it. So you find that, so what should happen? When you go to events these days, you'll find there's a disclaimer at the entrance that if you're entering this location, for images or videos will be taken. But the question is, a lot of people when they're entering that zone, are they the capacity? They might have consumed some substances, whether liquid or otherwise, before they get into that space. So are they in the mental state to understand this notice? But one way a service provider, the organizers can protect themselves is to have that notice out there. But then the question is, when is the notice provided? Because like, for example, in the EU, the question is, when did you provide this notice? Is it before somebody pays the ticket or after? Because look at it this way. You've paid for an event online, you have an e-ticket, you're getting in. Then when you're getting in, you're seeing that notice that we are taking photos, etc. That is not the appropriate time. The notice should have been done while you are paying for your ticket. That before you click send that M-Pesa, there's already a notice flashing or on the spot that says, by the way, before you pay for this ticket, please remember we will be taking photos, etc. So that way, the events organizers will be able to protect themselves. Another way, in some conferences, this day is happening that you give your attendees lanyards with different colors. So you have lanyards that are maybe blue and some that are red. The ones in blue are people who have accepted to their photos to be taken. The one in red are those ones who have said, who are indicating, please do not take my photo. So there are different strategies to deal with this. There's no one shoe fits all. It's just how, look at the situation and see how best to deal with the rights of the data subjects and also the duties and obligations of the service provider.
Actually, you've answered that very well. And one of the other things that we tend to do at the university is when people are attending, we have an image rights consent form. So you sign that, and if we happen to take your picture and we see your form that you didn't want that picture to be taken, we'll just blur out your face. Or sometimes we advise you, if you see the camera coming your way and you don't want, just turn the other way or put a mask or something. So that's something that can always be mitigated even if your picture has been taken.
Maybe for CCTV manipulation, basically this depends on the angle at which the investigating officer will take. Because in terms of evidence, if you read the Evidence Act, we talk of the actus rea and the mens rea. Before you realize that the CCTV footage you are using has been manipulated, what other information do you have to confirm that? How did you know even it's manipulated? You must have had other information. So in the surrounding areas, do you have any other CCTV footage? So this is a matter of an IO. How qualified it is, how experienced it is, how endorsed it is in terms of investigations. Thank you.
Okay, thank you very much. I think we've covered the ones so far from online. We will have one, there's a hand here, and then we will also go online. For those who are asking questions from online, please, our team here, enable them. So they will ask questions after she has asked us.
Thank you. I'm Obare Sheila. I just have two direct questions. One is about identity. In Kenya, normally our prime identification documents is your ID card, your passport. Now we are in the digital age, but you're still required to be carrying around your ID. At times, even when you go to these offices, somebody wants to even retain that ID card before you enter, then they can return it to you. In the digital era, what can we do so that we have something, an alternative of carrying the ID card, passports, and everything with you everywhere you go, and you need to deposit them before you obtain entry. Just on the same, even the Huduma numbers that were introduced, they're also cards. Take an example, a patient, someone has just dropped there. We are here, I'm an attendee here, maybe none of you knows me, and I did not carry my cards. I'm unconscious. How do I get services? So we need to think of a digital way of identifying somebody, maybe our fingerprints. By just putting the fingerprint, you're able to get all the details of this person are centralized, because all of us have national ID cards. And when you're taking the ID card, our fingerprints are taken. So if our fingerprints can be synchronized so that all our details are there, anywhere I am, I can just use it because I am here, the fingerprint is there. But these are things I can be able to leave them behind. The second concern was on, I've just noticed that the cooperative bank is part of this event, and I had a question on our banking sector. In our banking sector, we normally have those cards, the ATM cards. The cards have a card number, and if you look behind, there are those 4 digits. Actually, if I can get access to anybody's card number and I have those 4 digits, I can transact online transactions. And if you do not have a prompt to know that some money has been deducted, I can just use your card to pay for any services. I can just use online transactions. So how do we protect this consumer protection on online transactions? Because our cards are carrying the PIN and the card number. How do we protect them? Thank you.
Okay, I hope the COP people are here. But I like your idea of, biometrics. Although it reminds me of some old movies we used to watch of Chuck Norris, where somebody is abducted for purposes of just using their hand to open some bank vault to steal money. So I don't know what risk would come with that kind of idea, but it's something worth considering. At this point, I want us to take some questions online, and then we can have a final reaction from our panelists. Yes? Riziki, please. We are ready to take your question.
Thank you so much. I've been following the discussion quite keenly, and in Malindi. My name is Riziki Mukule. I'm an advocate of the High Court as well as council member in the LSK. Now, mine is actually a live case, and I want any of the panelists to answer, especially Dr. Laibuta. I had a Facebook account that had cultivated for over 10 years. Now, Facebook is different from other platforms like Instagram or LinkedIn or Twitter by way of interaction and the number of friends and the way you interact with them. Facebook, for one reason or the other, locked my account. It has all my memories, it has all my pictures, and even when I was campaigning for LSK, that is the forum I used. I want to know what my remedies are in light of IP and who owns the pictures that are there. Is it me? Is it Facebook? And if I were to feel aggrieved because I feel like maybe my consumer rights have, or something have been infringed, where do you get these people? Do they have locus here in Kenya? So vis-a-vis lifting the veil of such international brands, what are the rights of a consumer? And also, can we have special courts, special data courts with the people who have specialized knowledge of such ideas who can deal with cases such as this? Thank you so much.
Thank you, Council. Is there any other person online? None. I think, Laibuta, you can start us off special data courts and they respond to what Council Mkule has asked.
So, these platforms have terms and conditions of service, and they have policies that set out what are your rights. And these rights are usually, they have a lot of rights. They have IP rights, they have a data protection rights, etc. And they say if you are putting information on the platform, to what extent, what are your IP rights, what are your data protection rights. The challenge is that you'll find that, for example, meta platforms, for our African region, the headquarters are based in the US, where there is quite a weak protection of data protection, which is detrimental to us. So you find that if you want to make a complaint, you have to use the Meta online complaint system. Sometimes it's effective, sometimes it's not effective. On special courts, under the Data Protection Act, you can make a complaint to the Office of the Data Protection Commissioner. Look at it this way. For example, under Section 26 of the Data Protection Act, you have a right to access your data. So one thing is to make a complaint to the Office of the Data Protection Commissioner and say that this data controller or this data processor has denied me access to my personal data. And once you make that complaint, the Office of the Data Protection Commissioner will be able to take action. But I think one of the challenges is that there are no laws in Kenya that mandate these platforms to have a designated office of a designated representatives within Kenya. So legally, that provides a challenge. But I think for me, just from the top of my head, a complaint to the Office of the Data Protection Commissioner on the issue of lack of access to your data perhaps could be there. Then on the issue of banking, one of the sectors that I work in terms of providing compliance processes in terms of data protection is the financial sector. And the financial sector puts in place certain mechanisms to protect your information. And one of these is usually two-factor authentication. So if you are a customer of a bank that does not provide two-factor authentication when you are doing online services, that of course it's already a red flag. And secondly, if you're in a bank that does not provide you SMS or an email when a transaction has been carried out on your account, that again is a red flag because this should come up automatically. But however, there have also been challenges whereby you have people who hack into this system. One of the challenge that we have is that we have what we call external and internal cybersecurity threats. So you find that people working with these financial institutions, they also steal data, or people working in telcos, they steal data and want to sell data out there, and that data is made available to criminals. So you might make all these strategies, but also you dealing with that insider threat is a challenge. But for banking, look at issue security systems. Do they have a policy? Do they have issues like two-factor authentication? Do they have a seamless compliance mechanism? Do they send you SMSs or emails when there are transactions on account? And that way you can identify whether this financial institution has put in place measures. Does this bank have their systems down throughout? There are reports out here on people who do this ethical hacking on these applications, and they put information out and they say we've tested certain apps and we found those apps to be wanting. These are some of the information that you could be looking at to make a determination whether your bank is doing the correct things or not. think that's
Just lastly, your comment on whether we need to have special courts for data.
That's why I said, in terms of the courts, there's a complaint mechanism under the Data Protection Act. So under the Data Protection Act, you have rights. You have a right to make a complaint to the Office of the Data Protection Commissioner. So let's say, for example, somebody has, like last year, the Office of the Data Protection Commissioner fined Oppo Kenya 5 million shillings, and the issue was about improper use of an image. So it's an intersection between image rights and privacy. I must say, in Kenya, we are not separating these two. They work in the same system. So the same, if you are a financial institution and you find that your data has been leaked or has been used inappropriately, you make a complaint to the Office of the Data Protection Commissioner. There are regulations, there are complaints and enforcement regulations that tell you how to make the complaint, how the process, when the other person will be served, that the data commissioner can put in place alternative dispute resolutions mechanism to deal with this and make a finding. And that finding could be that you may be compensated, to ask that controller or processor to put in place certain organizational and technical measures. And of course, if you're not happy with the decision of the Office of the Data Protection Commissioner, the High Court is open for you.
Okay. Thank you very much. I don't know whether we have covered. Is there anything that any one of us wants to react to? There was a suggestion there by one of the participants that now that we have decided we are going digital, why don't we actually have digital ID that are not physical cards again, so that maybe they use your bio and it will be your eyes, your facial image. Maybe a comment as we come to the end of the session. Anyone can take on that?
Let's perfect our systems first before we can get there.
Okay.
Yeah, we crawl before we can sprint.
Okay. Yeah. Thank you very much. With that, we come to the end of this session. But just in 1 second, are we moving in the right direction? Yes or no? We'll start from that side, coming this side, and then we'll come to the...
Yes, I think we are moving in the right direction. Digitization is important. It makes services seamless. We just need to do a couple of tweaks here and there to ensure that the laws are capturing all aspects, particularly the gaps that are left in terms of privacy and data.
Okay, thank you. Yes, Laibuta?
So it depends. I mean, I'll give the lawyer answer. It depends on what sector you're looking at. Some areas we are doing well. Some areas there are gaps. So let us work together to address those gaps.
Okay, thank you very much.
Fine, we are moving in the right direction, and I call for the actors in the justice system that we come up with the case management systems that are similar, complementary, and very secure.
Thank you.
Okay, for virtual courts, also you are moving in the right direction, but there is still a lot of effort that is needed. There has been court orders still that the judiciary should improve on the systems, which has not happened. So there is a lot of effort that is needed still.
Okay. Now, with that point of hope, I wish to thank you all for sparing your time to engage in this particular discussion. I'm sure the participants here would appreciate that this has been a very good eye-opener, even as we look forward to more detailed discussions coming up in our program. So we don't take it for granted that you have availed this chance and that you have shared your expertise, which we hope will be impactful and will inform our resolutions going forward from this particular interaction. Can we all give them hands of applause? At this point, I wish to also thank yourselves for active participation. Clap for yourselves. And those ones who are following us online also, we wish to recognize you. At this point, I wish to return the program to Mrs. Nasserian to give us a way forward.
Thank you very much to the panelists, our moderator, and to everybody who participated, including our online guests. At this point, I would like to again acknowledge our gold sponsor for this event, that is the Cooperative Bank, and to give them a few minutes to address us and get to tell us about their services. Thank you. Welcome, Mr. Obaga.
Thank you very much, Nasirian. Yeah, I've enjoyed the session. I've really enjoyed it. I came a bit late, but I have really enjoyed it. Particularly enjoyed it because now lawyers are talking the digital language. In the banking industry, we have been there for some time now. You all know banking now is basically offering digital platforms. So I'm happy to note that in future, you lawyers, you'll have to do some digital course apart from what KSL is now training you on. So I'll advise the bank when I go back to keep the distance because lawyers are catching up. So my name is George Abuga. I'm a senior relationship manager, and I've been sent here to speak to you by my director, Jacqueline Waitaka, who could not make it, and I will quickly go through some notes she prepared. The director, Kenya School of Law, Dr. Henry Mutai, all CEOs present, all directors present, protocols observed. It is with great pleasure that Cooperative Bank joins you to participate, and also are privileged to be a sponsor of the Kenya School of Law 4th Law Annual Conference with the theme Law in the Digital Age. Indeed, the Kenya School of Law continues to play a critical role as a center of excellence in professional legal training, research, and consultancy. This has been made possible by offering quality, practical training in law and other related disciplines for the professional development of lawyers and other actors in the legal sector, and also to undertake research, consultancies, and projects. I wish to take this opportunity on my behalf, the Board of Directors and the entire Cooperative Bank Group, to convey our warm congratulations on hosting once again this auspicious event. Indeed, the school's passion for excellence gels very well with the passion of the bank to improve livelihoods across our dear country. As you'll be aware, Cooperative Bank is the third largest bank in Kenya with an asset base of over 600 billion, and we have over 180 branches with over 9 million account holders, and we are, as you are aware, predominantly owned by the over 15 million cooperative movement that forms the backbone of our national economy, which cuts across all economic segments, notably education, industry, marketing, housing, transport, and the circle movement. Kenya, as you are aware, as the most developed cooperative sector in Africa, with over 22,000 cooperative societies across all countries. The bank has undergone tremendous business transformation over the years, and hence are ready to serve you and the stakeholders who are here present. Since inception of the bank in the year 1968, the bank has been a key agent of the government in implementing the government socio-economic agenda, with the permanent secretary, Minister of Finance and Treasury sitting in our board. We wish you all the best, and once more, congratulations. and enjoy the event. Thank you.
Thank you, Mr. Abuga. That brings us to our lunch break. We'll take 1 hour and be back here at 2:30 p.m. because I know if I push you to do half an hour, you'll still be late, isn't it? Okay. Oh, that's my assumption. But let's be here promptly at 2:30 p.m. Now, in the afternoon, we'll have 3 sessions ongoing, 3 breakout rooms. So make reference to your program and see which sub-theme you're quite interested in. We'll have 2 sub-themes ongoing. The sub-theme 1 is law, ethics, and social media, and that will be conducted here in Mutula Hall and also upstairs. You take the stairs to your left, the first floor. It will be labeled Syndicate 1. I believe it's the one that's directly next to the stairs. There will also be other discussions on sub-theme 1, and then there will also be sub-theme 2 ongoing in Syndicate 2. Again, you take the stairs, you go straight ahead, you'll see Syndicate 2 to your left. It's the first room to your left. Once you go up the stairs, we'll have that session also ongoing. Any members of the Law Society of Kenya who would like to claim CPD points, please register your interest with Jacqueline at the registration desk, and also request all our presenters that are here to also see Jacqueline at the registration desk before you go for lunch. Otherwise, enjoy your lunch. Thank you. Online guests, you can also break for lunch and be back at 2:30 p.m.
into somebody's wallet. So to buy digital art, you need to have a wallet. So when you have money, you need somewhere to put the money. So it's like a bank. So a wallet, a cryptocurrency wallet is where you put your money. So it can be Bitcoin, Ethereum, or any other token. So somebody broke into somebody's account and stole 2 pictures. Okay, so 2 images, 2 NFTs, and sold those off to somebody else, right? Now, the thing you need to realize is when you buy an NFT, you're not buying the copyright, you're buying a license. There is a case where somebody actually thought they were buying a book. So the script was for the movie Dune, and they spent $3 million and they bought the script thinking they had the copyright and they could make other things, but they were only told you have a license, you're only buying a license. So be very careful when you're buying an NFT, you're only buying a license, you're not buying the copyright, okay? So these people, they transferred the work to someone else, right? But they couldn't be traced. Okay, so she didn't know who because they are anonymous according to the data. So there are potential risks with owning digital works, and NFTs tend to be quite expensive. Last year, somebody sold, I think the artist called Beeple, he sold his artwork called 5,000 Days. So he did 5,000 pictures over a period of 5,000 days, and he sold that for $66 million in NFTs. So they're quite expensive. Right. So these issues where it's possible to steal NFTs and then once it's gone, you can't recover it, is still something that really does need to be addressed. So we've discussed the issue of service to infringers. It's not easy because you can't always know the identity of the person behind the sales of NFTs. And this is perhaps a challenge that the laws can address better so that anybody who's going to have any transactions on the blockchain, we need to know who they are. We need to be able to sort of have some identifying data that allows us to know who the person is behind that NFT transaction. So on the issue of trademarks, so in the metaverse, it's possible to go and do shopping. So you can go and buy clothes for your avatar, shoes, cosmetics. And one case, although this is not really in the metaverse, it's got something that could potentially happen in the metaverse. So imagine you have your nice shoe shop and then you go and register it in the metaverse and somebody sees it and comes out in the real world and makes the same thing. How would you feel about that? That's still property, right? You'd want to defend your economic interest. And I think one thing we need to understand why people are trying to go into the metaverse, if you're a brand that you're known in Kenya, and you want to do business online, you want to be the only one to get money from people because of your brand reputation. So in this case, the company called Hermes, they make bags, expensive bags. There was an artist called, what was his name? I forget his name. So he copied the original bag, but he did a digital version and he made it with fur. And he called it the Meta Birkin. So he was selling this in a website, okay? And then he had actually got some NFTs and he was selling them for as much as $4,000. Hermes saw this and they were like, wait, that's our brand. He's riding off our brand. He's opened a website. He's telling people that these Birkins, Meta Birkins, actually look like Birkins, and he's making a lot of money. I think he made about $1 million from these sales. So Hermes goes to court, and actually the court decided in their favor and decided actually the trademark belongs to Hermes. You confused people into believing that this trademark actually belongs to Hermes, but it's not. Okay, so potential issues in the metaverse is people will free ride. And we have to remember that trademarks are jurisdictional. If you want to protect your trademark in Uganda, you have to go to Uganda and register it there. Okay. If you want to protect your trademark in the US, you have to go to the US to register it. But it's completely complicated in the metaverse because the metaverse has got no borders. So how do you protect your intellectual property when you can't register it in one specific place? So this is a challenge for intellectual property in the virtual space. Another example, so Coca-Cola, in one of the games called Roblox, they launched this drink called Coca-Cola Bite. So it's a limited edition. But along the way, they've also, in the real world, launched the drink as a limited edition drink for people who want to buy it. So you see, it's possible. Things that start in the virtual platform essentially can transfer into the real world, and then brands that own those things want to protect them because people can free ride on those big brands to make money online. The issue of image rights. So there are some AI generated works. So if you go to an app like Midjourney, you can put a prompt in and you tell it, I want this thing that looks like this celebrity, and it generates this image for you. So there's an image of someone who looks like Jason Statham and The Rock, right? And you'll notice, like, when you go to social media, people have got avatars that look like celebrities attached to them. And one thing about the metaverse is they're going to have skins. So skins are going to allow people to put any picture of people who look like celebrities into the virtual space. And so there are image rights issues. Is it okay to allow people to have skins that look like you, even though it's not in the real world, in the metaverse? Remember, in the real world, you have publicity rights, so you control how your image is used. Is this okay? In as much as it's in a virtual space, is it okay for people to use images that look like other people in the virtual space? Okay. So then there are other issues. So you can buy real estate, but under copyright law, architectural works are actually protected under copyright. So when you go to the metaverse, you'll see very many buildings that probably the people who designed the metaverse should have got permission for. So I'm seeing a case of litigation in terms of ownership of copyright works in the metaverse. And then, of course, it's a potential area for lawyers to make money. If anybody wants to get into IP, particularly IT and IP, then this is a good space to be in, because you essentially will be drafting contracts and doing litigation for people who have had their works infringed in the metaverse. So this is an interesting space. I think you should definitely look more into it, especially now that it's developing. Don't be left behind. And I hope that we'll have some very good discussions in terms of how to address some of these policy issues. Okay, that's pretty much it. Thank you.
Well, I hope I'm audible enough. Good afternoon, everybody. Good to see you here. My name is Sophie Nekesa Wanjala. I am a lawyer. Right now, I am a pupil at Mstiuki Mogaka and Company Advocates. And as the slides prepare to come through, I would like to introduce the topic I'm going to present. The theme being law, ethics, and social media, and specifically data protection. This has been the subject. It has taken up more time during the morning session, so we are not going to take long, I promise, but I saw many questions around this area. So in case you have any concerns that was not answered, or the one that will come up during the presentation, I encourage you to raise it so that I can be able to address it in the best way possible. So before we start, I would like to ask you a question, sir. Can I? What is your name? Oscar. Oh, Oscar. Okay. If I ask you, Oscar, that I would like to know how much money you have in your bank right now. You're in a deficit, hypothetically speaking. 100,000 shillings. Right. Okay. Let me ask a lady. Excuse me. What's your name kindly? What? Catherine. Hi, Catherine. If I ask you how many children you have? How many children you have? 10 children. How many children do you have? You don't have any children. So we are going to come back to Catherine and ask her. So let's first talk about data protection laws and policies. I hope they can be seen from where we are. So before we understand data protection, we need to talk about data. What is data? What do you understand by the term data? Data is information. Information that can be used for decision making. Information about someone. Information about something. Catherine has just said she has 10 kids. That is information about Catherine. Oscar has told us he has 100,000 in his bank account. That is information about you. Information, now that the theme for this year is law in the digital age. Information is stored in computers for accessibility. Previously, we used to have papers. There used to be so many papers in government institutions. Even at the courts, you would go and you will see a pile of files. You cannot be able to find your file because there is so much that people have to get through to get to your file so that you can be able to use it. So nowadays, we are in the computer age. Data is stored in the computer, and that way it is easily accessible. Data processing. Data. Catherine has 10 children. Oscar has 100,000 in his bank account. That information is useless. That information is useless if no one can use it. And you can only use data if you have processed it. So what is to process? To process is to collect. It is to store, it is to use, it is to share, it is to discard the information. The whole of those, all those processes, they make up what we call data processing. Why do we need data processing? We need data processing so that the data can be stored in a form that can be easily accessible, that can be easily used. Data is useless if no one can be able to use it, if no one can be able to access it. If you cannot store information for use, it is useless. That is data processing. So when we talk about data protection, Data Protection Act, which we'll be coming to, is an implementation of Article 31 of the Constitution of Kenya. Article 31 talks about privacy. Privacy is that it's an element of liberty. It is being able to control information about you that no one knows. it is being able to be autonomous, to make decisions about yourself without anybody's influence. That is privacy. And privacy is recognized as a human right, as I've said, under Article 31 of the Constitution, the Bill of Rights. And it is also recognized under several international instruments. You cannot mention human rights without mentioning the international instruments because they make part of the Kenyan law under Article 26 of the Constitution. And the right to privacy, being alone, to be left alone, to control your information, it is not absolute. It is not absolute in the manner that someone else can access that information. But as we are going to see, someone who is accessing that information, they need a reason to access that information. They are not accessing the information for their own fun because they like it or because they are going to give to that girl because they like the girl. They are going to submit the information to this institution because they work in that institution and that is their mandate. How are they going to get that information from you? That is the focus of this discussion. What is the justification? What are the boundaries of them accessing your information? What are the challenges of accessing this information? Remember, the information is protected. We are talking about data protection. How do they get that information? What is the justification for them to get the information? What is the basis? Do they have jurisdiction or locus to get that information from you? Are they allowed legally to get that information from you? And what are the challenges that will be experienced when processing your data? So data protection started way back in 1800 in the USA, actually. There are two lawyers who came up with the right to privacy. They wrote an article called Right to Privacy. They said you have a right to be autonomous. You have a right to be left alone, to control the information that you have about you that no one else has. Privacy. So that was in 1800. The Freedom of Information Act came into effect in the USA. Just around that, about 1900. So we can debatably say privacy and data protection started in the USA. Then it came to Europe. When it came to Europe, a lot of statutes were enacted by the European Union. They were enacted for people who are processing information about Europeans, people who, the processors who are located in Europe or processing information about Europeans. So out of that influence, it spread across the world. And right now, over 100 countries, including European Union states, have data protection laws. Now, when you're processing data, you need to comply with some regulations, which we are going to look at. But out of the USA and out of Europe, now that the same has been taken up by so many countries, let us come closer to us. I would have started regionally, like East Africa, but currently we do not have such regulation. So let's come closer home. When you talk about data protection in Kenya, what is the justification for data protection in our country? Which data is supposed to be stored where and by who and why? So we look at some of the statutes that are in place even before the Data Protection Act that came that came in 2019. We look at some of the statutes that exist that are closely related to Data Protection Act. Your financial information, your bank accounts, how much have in your bank account, Mr. Akas, is regulated by the National Payment Systems. Your information as a consumer of any product is regulated by consumer protection guidelines, and the list is not exhaustive. You will find that there are so many other related statutes that regulate the same data. But for purposes of the discussion and time, we are just going to go through the main ones. Elections, we have the Elections Act, we have the Political Parties Act. So they keep the information about elections. Catherine, where do you vote? Which is your area? Which is your constituency? Which is your county? All that information is kept. It's protected by the Elections Act and the Political Parties Act, where you belong. So let's look at data protection principles. If you want to protect data, you do not do it the way you want. There are some principles that you have to follow for you to protect the data so that it does not fall in the wrong hands. Right to privacy is the very first one. Remember, as I mentioned, the Data Protection Act is an implementation of Article 31 of the Constitution, which is the right to privacy. Lawfulness, fairness, transparency in handling your data. Data minimization. If someone wants to employ you, Catherine, do they need to know your DNA, for example? They don't. Data minimization. They only collect the data that they need for that purpose. Accuracy. Ask her if they say you are 10 years old. Is that accurate? You have? You have been told in mind? Okay, definitely it's not correct. So the data about you has to be correct. Storage limitation. You are employed by Teacher Service Commission. You have quit or you have resigned. Why are they keeping your information? Do they need the information right now? You quit the institution. That is just an example. Integrity, confidentiality. Nobody needs to know some details about you. Privacy. When you are processing data, there are some restrictions. There are general provisions for processing data, and then there are restrictions when you're processing data. And these restrictions come as a result of the data commissioner. Now that we have the data commissioner in place, courtesy of the Data Protection Act, there are some restrictions when data is being processed. That comes as a result of categorization of data subjects. We'll be coming to that. Data about you. You are the data subject. This information is about you. You are now the data subject. So remember what I told you about processing of data. Collecting, storing. What? Collecting, storing, editing the information, using the information, discarding the information. That is processing. Children, you do not just meet a small girl on the street and then you start asking their details. It is restricted. It is restricted. They need to have a parent with them or someone else who has legal rights over the child, a mentally incapacitated person. You cannot go to Madare Hospital and pick any mentally ill student and start asking them specific details. Their information is processed under the Mental Health Act and other enabling provisions of the law. Commercial use of data. We recently saw on Facebook, for those of us who browse the social media, someone sued the university for using their picture from another university to market their university. I don't know how many of you saw that. Commercial use of data. They use your data to market themselves, to get clients for themselves, to get income for themselves without your consent. We'll be coming to consent. It is restricted. Data portability. You want to move from Old Mutual Insurance to Jubilee Insurance. The information that you have at Old Mutual should be able to be transferred to Jubilee Insurance in a structured manner. That is data portability. So we are now talking about rights of data subjects. Section 26 to 38 of the Data Protection Act. Access to personal data. You should be able to have access to that data. It is yours after all. You can decide which kind of information can be processed about you. Can we process this? Yes. Can we process this? No. And that should suffice. You have a right for your information to be corrected. If the Kenya National Bureau of Statistics or whichever institution says Catherine has 15 children, it is incorrect. Catherine has 10 children. She has a right to go there and say, no, this is not correct. You are processing the information wrongly. It is not correct. I need the information either corrected or deleted because it is a misrepresentation. I mentioned earlier that the data commissioner can categorize data subjects. In the same way, the data commissioner, the office of the data protection commissioner, can categorize data, personal data. We are dealing with personal data. So there's personal data and there is sensitive personal data. Where ASCA lives, that is personal data. ASCA's biometrics, that is sensitive personal data. His DNA is sensitive personal data, which should be processed in line with the data protection principles that we looked at before. You can ask a question in case you're lost. They should be processed with support of legal claims or specific objectives. Why do you need to know his DNA? You must be seeking to either claim a certain right, protect a certain right, or enforce a certain right for you to have access to that information. For his house is okay. But the DNA, the biometrics, that is sensitive personal data. So let's look at how can you comply with the Data Protection Act and other regulations. Remember, we have other regulations and other policies in place that are not the subject of this discourse, but they are there. So organizations need to comply with the requirements of the Data Protection Act. You need to comply with the need for data processors and controllers. We can discuss that one. And there exist many ways to comply. Under the Data Protection Act, you have to register to be a data controller or a data processor. The Data Protection Act created offices, regulators to be in control of the processing activities. At the helm, of course, is the Office of the Data Protection Commissioner, who was with us virtually in the morning, Miss Kasit. So there's the Office of the Data Protection Commissioner. We have data controllers. They decide how your data is used. For example, a school, a hospital, a club. Those are data controllers. We have data processors. Data processors, most of the time, they simply collect the information on behalf of the data controllers. So for you to be a data controller or a data processor, you have to register with the Office of the Data Protection Commission. You have to adhere to the data protection principles for you to be in compliance with the Data Protection Act. You have to carry out a data protection impact assessment. And when we talk about data protection impact assessment, we are talking about when this data is being processed. How is it affecting the rights of Catherine? The Bill of Rights. How is it affecting her freedoms that have been guaranteed by the Constitution? So you have to weigh if they are likely to interfere with her rights and freedoms. You cannot go ahead and process the data unless you have approval of the Office of the Data Protection Commission, or it is very essential in protection of another legal right. Notifying the data subjects. Notification of the data subjects happens when your data has been leaked or there's a breach. You gave your information to a hospital, you are HIV positive. That is very sensitive data. Now that information has leaked. This is just an example. They should be able to tell you. They should be able to notify you. Of course, there are ways of being notified. We can look at the Data Protection Act, or you can raise a question later. You need to notify the Office of the Data Protection Commissioner, like I mentioned, if there's a breach or there is sensitive data that cannot be processed without the consent of the owner of the data or the Office of the Data Protection Commissioner. So what happens if you do not comply? Laws do not exist in a vacuum. There's a reason they're made, so that we can have some order. Of course, all of us would like to conduct themselves the way they like. But the reason we have laws is to police our behavior in relation to other people. You have rights, yes, but just remember the person seated next to you has rights. You want to play music full blast. What about your neighbor who doesn't like any kind of noise? He is a human being too. He has rights. So it has to balance. So what happens if you do not comply with the data protection laws and policies? So data can land in wrong hands. Your enemy can use the data against you. If you are a data controller or a data processor, they work together, they work hand in hand. They're likely to sue you. You remember the example I gave you about a student who sued the university? They can sue you and you will incur a lot of costs. Those are the costs you are supposed to use to improve your company to make profits. Your reputation will be ruined. Businesses will go down. And other consequences. The list is not exhaustive. So what are some of the tools that we can use to protect our data? So we have a list here. Anonymization. Anonymization means you see the data, but you cannot identify exactly who it belongs to. A bank has several customers with a balance of 100,000, like Aka said, but you cannot specifically pin some 100,000 to him. Anonymous. Closely related is pseudonymization. Pseudonym. A pseudonym means something that is not real. On social media, people use pseudonyms. They don't use their real names. Why? Some have legitimate reasons, some do not have. They simply want to bully others on social media. So you cannot tell exactly who is this without some information. Pseudonymization, some information is hidden. You cannot tell who that person is. Encryption. You are protecting this data using codes, a coded language. So unless someone knows the codes, they cannot access the data. They can't know what is this encrypted data. I'm sure you have seen on our WhatsApp pages, WhatsApp platform, this information is what? Encrypted, end to end, coded. You cannot access unless you know the codes. Protecting data. Controlled access, simple. Only Catherine can access information about her, and only the school where she is can access the information. Nobody else needs that information. You control access. Offsite backup. You have the whole information about if you are a management of a hospital, you are a data controller, you have all this information somewhere else. In case power goes off totally or you are hacked, offsite somewhere else. In case you are hacked or power goes off or something, you are able to come back to business immediately because you had backup. Training. If we are talking about data protection here, hypothetically, if all of us are students, we are talking about data protection. You are a cleaner. I am a cook. He is the manager. He knows data protection. I don't. I can go to his computer and someone can call me and say, can you send me my financial information or what is? I go to his computer, I send that information. I do not know that it is wrong. I did not know. There's no sensitization. So there needs to be training from up to bottom, or is it bottom up? Okay, everybody needs to be sensitized about data protection. They need to know what are the boundaries, either physically or even in machines. Which kind of information can I access from your machine? Can I come to your office anytime, for example? Boundaries need to be clear. People need to be trained to know these things. It's important. Monitoring and reporting. The systems that you have in place for data protection, are they working? There's need to monitor the systems and to report in case they fail. In case they fail to protect the data that we need it to protect. Data protection is not without challenges. And these are just some of the challenges that organizations are going through in their bid to comply with the data protection policies and challenges. Lack of awareness. They don't know. They don't know that these policies exist. They don't know that these are the consequences. So they go on breaching the data protection laws and policies. Lack of proper documentation. Information about human resource, some papers are here, some papers are there, some papers are completely disorganized, chaotic. You cannot control data if it's not in a location that you can access and control it. Lack of standards for cross-border transfer. At some time, during this discourse, even in your own time, you'll realize that data sometimes needs to be transferred to another country, either for performance of a contract, in your benefit, mostly. So there are rules to regulate that. You don't just wake up and transfer your data to someone in the US. Lack of privacy compliant systems. If this laptop does not have a password, anybody who is passing will just come and maybe it has sensitive data, but you see it doesn't have a password, and human beings being who we are, curiosity, I come, I check the emails. Non-compliance with privacy. Processors struggle with consent management. Consent is a very big aspect of data protection. Before your data is processed, there needs to be a consent. You need to have said, yes, process the data, store my data, delete my data, edit my data, consent. And it needs to be clear. Because if you come and say, Kenya School of Law, I did not tell you to process my data, they have a burden to tell us where they got the consent. to process my data. I did not tell you to process my data. Consent. Skip that one. Sorry. So the conclusion, privacy, actually data protection comes from privacy. You cannot talk about data protection without privacy. Data about you, privacy. So it's a contemporary subject and the discussions keep going, even as we have the Data Protection Act in place. The judiciary plays an important role in all this. When you go to court and a decision is made, that is the law. If you go to a high court and a judge pronounces a ruling or a judgment, that is the law. Unless it is reviewed or appealed and it's successful at appeal. Wherever it is, when a judge pronounces a judgment, that is the law to follow. So they play a crucial part in the matter of data protection. Nations have to agree on cross-border laws that will safeguard data. We do a lot of business with Ugandans, Tanzanians. If your data goes to Tanzania, is it protected there? If my data goes to Uganda, is it protected? So that is the discussion that we need. There's a gentleman, I think he left the room. There's a gentleman who was there who asked a question about, I don't have control. He said, not exactly verbatim. He said, I don't have control to my personal data. Like many people or organizations are using the data in a way that I do not like, but I need the service. So there needs to be a balance. You're going to withdraw money from M-Pesa. They at least need your ID. Like there needs to be a balance between the person asking for your data and the justification. But there are some which go beyond. And those are the illegal parts. So anytime you feel that your data has not been properly used, it is an infringement on your rights. Privacy is protected, is a protected status, protected by the Constitution of Kenya, now the Data Protection Act, and several other acts that we looked at before. So if anytime you feel that any of your rights has been infringed upon, you go to courts. Look at Section 22 of the Constitution. Everybody has a right to go to court and say, my rights have been infringed, or they're being threatened, or they've been violated. Privacy is your right. Go to court. Look at Article 258. Any of that provisions in the Constitution that has been violated, you as an individual, a Kenyan citizen, you have a right to go to court and say, no, Kenya School of Law has violated the Constitution. So an individual right, Article 22. The Constitution generally, Article 258. Thank you for attending. I'll be open to some questions. Okay, thank you so much, members. I've been directed that we will be able to get the questions together and then we can address them at the end. Thank you so much for your attention.
Good afternoon. I'll be presenting my own version of the law in the digital age. It's nice to see some colleagues. Hopefully there's not too many questions that boggle my mind. So with that, I'll begin. So the first thing is my overview. So the overview will tackle the introduction, which is the scope of the paper. I've divided it into specific parts, which was the digital age in Kenya, since we're pushing for digitization of key governmental services. And then I found fintech really interesting in relation to the advancements it's made with technology and how the legal sector can take inspiration from that. And then I moved on to the legal sector and the role of AI and how social media is becoming a critical issue in the legal profession. Then I'll cover briefly surveillance technology and how it's posing a threat to democracy and our data rights. And then finally, I'll provide some recommendations for the digital age with a conclusion. And finally, a thank you. So as an introduction, the digital age is what you can term this generation's industrial revolution. It has revolutionized every sector and reshaped how we communicate and how we disseminate information. It has facilitated great economical and social development, especially in Africa. And you can see why, based on all this information, the Kenyan government has decided to digitize key government services. And the legal sector had to embrace the digital age mainly due to the pandemic. But even before this, there were certain aspects of legal sector that was already digitized. The ubiquitous use of social media platforms and the rise in surveillance technologies have created challenges, and these will be discussed along with the recommendations. So, as I mentioned, the digital age, it's ushered in an age of enormous potential and growth. It has promoted globalization, where law firms now operate cross borders, and it's provided unlimited access to information, communication, and economies of scale. It has played a crucial role in facilitating Africa's economic growth, and this can be seen through the use of technology in the financial sector, which I'll speak about later on. Kenya has already showed a knack of digitization based on how they've digitized services through eCitizen, RDSASA, iTax, and a few more. And Kenyan legislation has also tackled this. Kenya has had the capacity to digitize services through their internet ecosystem, and they do have a previous experience in relation to this. So on to M-Pesa and fintech. Fintech is the combination of the words financial and technology, and it's enhanced efficiency, accessibility, and inclusivity in that sector. It's reached those who never had access to financial services. It's banked the unbanked, and it has achieved great feats in promoting this financial inclusivity. And an example of this is mobile banking, and this takes us on to mobile money. And in Kenya, we had M-Pesa, which was pioneered in 2007, and it has promoted financial inclusivity in Kenya. It's benefited our nation and our population, and it has had a great impact on the nation's GDP. M-Pesa and the rise of fintech show the benefits that the legal sector can capitalize on in the digital age. And it further shows Kenya's capacity for digitization. There's a number there of $1.6 billion, and it shows just how much of an economic impact the use of technology can have on a sector. That $1.6 billion was M-Pesa's transactions in the first 2 years. And you have to remember this was during a limited scope. So since then, it's been truly astonishing. And I definitely suggest you go and read a case that's going on right now with regards to Safaricom. This case will provide you with more guidance as to why regulation is so important in the technological age, where when you allow these organizations to operate in a vacuum, it can lead to the violation of fundamental rights. It can lead to all sorts of issues in the legal sector. So this takes us on to the legal sector. From everything I've mentioned, we can take inspiration from the financial sector with their use of technology. The Kenya Law Review is, I think, a platform that we're all very familiar with. It's a digitized platform that stores cases and other materials in relation to the law. This is statutes. And what it has provided is greater access to these materials for the general population. Then there's other statutes which require digitization, such as the Land Registration Act, which under Section 10 requires that the registrar maintains digitized versions of key land documents. So as I mentioned, COVID-19 acted as a real catalyst for the digital age in the legal sector, and this can be seen in the practice directions of 2020, which introduced the use of technology in the courts. The legal sector promptly followed suit based on this, and we've embraced legal technology in the sense of cloud storage, and it's paved the way for the rest of us. So the rise of legal tech in the digital age has been monumental. And legal tech is the use of any technology. This is just a broad version of the definition. It's the use of any technology to facilitate and provide access to legal services. So this encapsulates a variety of technologies. So the digital age has created challenges, but it has facilitated the improvement of the legal profession. What these efficiencies have created is a lawyer or an advocate that can now devote more time to their client and less time on tedious tasks. So the role of AI, something that's really taken the world by storm. I think all of us have heard of it. It's ChatGPT. And this is the next frontier for the legal profession. It has already enhanced how we conduct our work, providing cheaper solutions and increasing efficiency. The innovation of this chatbot named ChatGPT has revolutionized how we can disseminate information and undertake research. So ChatGPT is a language-based AI. What this means is you don't just go onto it like it's Google and type, what is this? If you want a more detailed and more nuanced answer, you talk to it. You break down information and you can ask it based on the information you've provided. What is the law in this place? And it can give you really detailed information. Due to this, you'll see a top law firm in the UK called Allen & Overy, who have sought to capitalize on this technological development with their own creation called Harvey. They've already mentioned this has redefined how their multinational workforce operates and how it will automate tasks. Now, in terms of our legal work, AI has produced various efficiencies through data-driven analysis, natural language processing, and machine learning. This has improved areas such as discovery, document generation, and legal analytics. So in discovery, it's where you search a database using keywords, and these algorithms will provide access to documents that are large, but they'll provide you the sample, so you can have a look at the sample of a larger document. This allows you to review large documents in less time. In document generation, this is something that we already have in the legal sector, but this takes it to another level in the sense that it allows you to tailor contracts based on your specific circumstance. Coca-Cola has already implemented this, and they've noted the vast benefits. So it reviews their contracts and allows them to draft their contracts. Then the use of legal analytics, where it uses algorithms to combine data and analysis to identify patterns in making a legal decision or a prediction. So what this does is, before you go to court, you can use legal analytics to get an overview of what the likelihood of your case success would be. So this allows you to give better advice to your clients and allows you to gauge the success of your case. Another area that's been really redefined is ADR. ADR obviously is alternate dispute resolution mechanisms. This has been redefined through online dispute resolution mechanisms, where it's the use of tech through video conferencing and digital presentations using the internet. So the use of AI promotes standardization and consistency in these arenas. It's lessened costs and reduced the workload for arbitrators and judges alike. It has created a better experience for the clients, which I think is the most important facet. eBay uses ODR in e-commerce disputes, and it resolves more than 60 million cases a year, which shows its efficiency and its inclusivity. It's undisputed that tech in ADR has promoted access to justice and efficiency. That's why AI has enhanced competition by allowing smaller firms to compete with larger firms through various tools where they can research faster and provide better services to clients. I've just provided a brief glimpse of ChatGPT and the questions you can ask it and the types of answers it will give you. So I've provided on the third picture that you are an expert legal practitioner, judge, advocate, or lawyer. Use this knowledge of the law to explain to me the principle of the rule of law and its provision in the Constitution of Kenya. You'll notice I've produced a more in-depth prompt for that specific question, so I can get a more in-depth answer that provides better information. So, social media. Social media platforms are truly unique. They offer us a personal and a business purpose. It's become a fundamental tool for business growth in Africa, and this is through its economic and social development. They provide an instantaneous source of information and act as a town hall where we can share our views to thousands of people. When used correctly, it can facilitate business growth and connect you to potential clients. But when it's used unethically, it can lead to hatred, violence, and discrimination. And we've seen this in a variety of cases, such as the Capitol attack. So the key thing with social media platforms for the legal profession is how we use it as potential lawyers, as advocates, as judges, because it can lead to termination or lack of opportunities. Law firms are now looking at our digital footprint to identify whether a certain employee is suited to the role or not. Now, the key reason why we need a guiding policy is because of these challenges in relation to the use of social media. Legal professionals may be unaware of their potential breaches of confidentiality through their use of social media. This has muddied the grounds over its personal or employment use. So this is where it causes a bit of a disillusionment in the legal sector, where we don't really know when it's being used in the personal capacity or business capacity. We don't have tests for this, unlike, let's say, vicarious liability. We know when it's employment and when it's personal. So the misuse of social media platforms could have detrimental effects on the legal profession and the legal fraternity as a whole. I won't mention instances of this because I'm just starting out my legal journey and I don't want it to stop just yet. So I'll let you guys go and do some research on that. Now, the challenges that social media platforms have raised have not just been limited to lawyers and advocates and lecturers and students, but also judges. It's created a challenge in how they can dispense with justice. And these are key issues where it may raise biases in judges when they don't realize because of their use of social media. They can't be these autonomous beings where they don't use any source of technology, because this would mean they're not cognizant of the population they serve. And the key thing with a guiding policy is that we need the Law Society of Kenya to develop one, and this would allow the rest of the legal sector to follow suit. At present, the Code on Ethics, the CSPE-PEC from the LSK, is not sufficient. It provides a few rules here and there, but they provide ambiguity and uncertainty. That's why we need a more defined social media policy from the LSK. Now, when firms implement any social media policy, they need to be careful in relation to their employees. They need to provide a balancing act so that they don't cause a rift with their employees. This is why LSK needs to develop a coherent social media policy with consequences over breaches. Now I'll move on to the fundamental rights in the digital age. So, as I mentioned, social media platforms and technology have provided innumerable benefits. They provide a platform for billions of people to speak on civic, political, and economic affairs. It has connected citizens and governments, especially in Africa. However, with this rapid rise and development of technology, it poses challenges. And one of the challenges is that the law can never really keep up. The law has to be reactive rather than proactive, as technology is developing at a faster rate than the legal sector can keep up with. One of the other issues is that it has blurred the lines between the violation of fundamental rights. And the thing with this is when state interference comes in. Under Article 33, and in the Kenya Human Rights Commission case versus the Communications Authority, it was said that collection of data is a violation of your right to privacy. So in this case, we've understood it's a violation to your right of privacy. But Section 51, subsection 2, subsection B of the Data Protection Act provides that in the case of national security, surveillance technology is permissible. There's no real definition of when national security is involved. So this means that is it just on a pendulum? It's just based on that day and on that specific circumstance. So it's contributed to the perpetual abuse of human rights through the lack of moderation. And an example is Facebook and its role in Myanmar, where it promoted violence in that specific state. And currently, the case of Katiba Institute versus Meta shows this, where in Ethiopia right now, there was a case where it incited violence and basically it caused a lot of bloodshed. So another issue with the digital age is algorithms. Algorithms can contribute and perpetuate human rights abuses. This is especially the case where when an algorithm is designed, it has algorithmic bias. And when it has this, it can be specifically designed by the developer, or it can just occur without the developer being cognizant of it. Based on all this, we need a coherent framework once again that tackles these issues. The Data Protection Act is a good step, but more needs to be done. We need to build on this. And with the rise of AI, we need to look at what ChatGPT is going to do to our future. And this is why the EU is already looking at implementing a new bill tackling new AI technologies, and Italy has already banned ChatGPT. Now, surveillance technologies. Surveillance technologies are a valuable tool in the arsenal of governments around the world. It provides them with access to track and identify citizens, which erodes the fundamentals of democracy. Specific spyware that's been utilized around the world and beyond the ambits of governments and the legal and the law is a Pegasus spyware. This Pegasus spyware provides access to mobile phones, and they can track your data. They can see what messages you're sending, what calls you're taking, what pictures you're taking. And there needs to be regulation around this to clamp down on these private actors. So another issue is that this technology can be abused by authoritative regimes and criminal organizations, where they can use it to reach an unjust end or to subjugate their population. Social media platforms have been exploited for their data by state and non-state actors, as it is used as a surveillance tool. This is also an issue where commodification of data has become a prevalent thing, where social media platforms, in the pursuit of profit, do not mind selling data to all sorts of organizations. Now, the abuse of the private sector has been well documented, and the case of Cambridge Analytica shows the private sector exploiting personal data. Now, the private sector has not been clamped down on by governments around the world because they rely on their technological developments, because the government cannot keep up with these private agents. Now, as I mentioned, the Data Protection Act does not adequately cover surveillance technology due to the blanket ban under Section 51. That's why it is crucial that safeguards are put into place over surveillance technology. Now, I'm going to speak about the future of data protection. As I mentioned, the current legal framework is not sufficient, as it leaves gaps for exploitation and the rise of AI. So based on this, what we need is a comprehensive framework and safeguards. And what we can look at is, the first thing is moderation. So content moderators in Kenya, the content moderators decide what you see. They control traffic, and they're the ones that, and this is mainly done by algorithms and humans. The issue is that in Kenya right now, we had one of them was, I believe, called Samsos for Meta, and they were the ones that moderated the content in sub-Saharan Africa. So you can imagine how vast sub-Saharan Africa is, how diverse the language is, but they just had one branch in Nairobi to control all that, which is not sufficient. You cannot control that many people. So that meant there was perpetual abuse of human rights through posts that they couldn't take down because they just didn't have the manpower. Another issue is algorithms need to be finely tuned, because what they can end up doing is promoting human rights abuses. They can take down posts which are promoting human rights, but keep posts up that are abusing human rights. An example can be seen from the YouTube video over the atrocities in Syria. So the next thing is expiration of data. So expiration of data is a right that can be introduced in relation to how we view what we view on social media platforms. So algorithms are fed by years of data based on what we like, what we don't like, and this is what produces the contents we see. So based on this, data should expire as a person's interests and preferences, hobbies do change over time. We're not the same person we were 10 years ago. So rather than consent being eternal, we should probably have a time frame for them to be deleted, let's say 5 years, because we're changing. We want to see new things, we want to see things we enjoy. So based on this, we can introduce a right to expiration of data. Another thing is that social media platforms usually take consent in the sense of you signing up to those platforms as a right for them to use your data. Based on this, we should also provide a 5-year limit where once we've accepted our data being mined or our data being used, there should come a point where that data expires. The third data protection law that can be created is a right to a clean and healthy digital environment. We currently have this in the Constitution under Article 42, but what we need is something that reflects this in the digital sphere. What this means is that we don't want to see data pollution is a big issue in the digital sphere. We don't want to see the same content. We don't want to see content that we don't enjoy. So what should be, there should be a safeguard that makes sure that we don't constantly see content we don't want to see. An example is when we go onto Google, we can search a bag. As soon as we open Instagram, what's the first thing we see? Bags. So this is something that we need to clamp down on. Now, I'm going to move on to the recommendations for the digital age. So the first recommendation, these are by no means a closed list. This is just a few glimpses into what we can introduce. So a right to internet access. With the government's push for digitization of key services, it is fundamental that they do not alienate the population. They need to make sure that the population has adequate facilities to log on to their digitized platforms so that they're not alienated. Now, the Constitution places an obligation on the government under Article 6, sub-Article 3, to facilitate access to these services. Since services are going to be digitized, it is feasible to think that this should become a right, as it can provide an access platform for access to important digital skills, digital opportunities. And one of the key things is Finland. Finland can be a source of inspiration because they've introduced a right to internet access where they began with 1 Mbps for everyone. So this is a good place to start from. Obviously, it can be argued that Kenya has more pressing concerns, but this is one of the things that's already been spoken about by different ruling parties. Now, the second recommendation is amendments to the remuneration order. So I've mentioned that the use of technology has revolutionized the legal sector and how it's enhanced our efficiencies and how it takes less time. The problem is that lawyers use a billable system. What this means is the more time a matter takes, the more money you make. But now technology has resulted in efficiencies. What does that mean for the billable structure? So what the recommendation is to move away from the billable structure to a more advanced and more technological reliant structure, where it is cognizant of the advocate's knowledge, skills, and expertise. It should be a fixed, hourly, or outcome-based structure. And legal professionals need to reconsider their business models for the digital age. Now, training and education. With the push for digitization, it's critical that we have a population that's cognizant of how to use technology. We need to have a judiciary that understands the technological advancements and how algorithms work, how big data operates, how AI is changing the way we communicate around the world. And this also falls on to legal practitioners who need to constantly enhance their skills and knowledge. Now, another thing that should be really considered is educational institutions such as KSL providing students with the necessary knowledge and skills for the digital age. For example, they can introduce a course on digital ethics, and this would cover the morality in relation to algorithms and how we collect data. So the knowledge and skills that the government provides to the citizens will allow them to access the innumerable benefits of the digital age. Now, investment in technology. A huge challenge of the digital age is cybersecurity. There's the threat of hackers, spyware, and ransomware. These are a real threat to governments, companies, and the legal sector. As I've mentioned, the spyware that is Pegasus. Hackers can have access to personal and confidential information where the systems are vulnerable. The PwC noted an increase in spending by firms on their cybersecurity. This is the next step in the law. More law firms are using more online storage mechanisms and things like that, and they need to make sure those platforms are safe. And this also falls on to national security. Given our data is now going to be digitized with more digitization of government services, it's crucial that our personal information is kept safe. The use of encryption has already been mentioned, and this is one of the means of protecting data. As AI develops, it's going to protect more and more. But on the other hand, it acts as a double-edged sword, where as AI progresses, what this means is hackers get new tools as well to attack vulnerable system. Another issue is cyber crime as a business. This has developed into a private sector organization where a lot of money is involved. So investment in cybersecurity guarantees confidentiality and mitigates cyber risk. I don't know if any of you recall the Panama scandal, where a lot of digital information was leaked, and this can be detrimental to nations and organizations. Now, I'm going to speak briefly about blockchain technology. I'm not going to go in depth into blockchain because that requires a whole seminar on its own. Now, the first thing to note is blockchain technology is not Bitcoin. It's a lot more than just Bitcoin. It has other uses apart from the financial sector. Now, blockchain is a form of distributed ledger technology that offers a secure decentralized system. So the blocks are in relation to data, and each block creates the chain. This is blockchain. So the applications for this technology goes beyond the legal sector, as I've mentioned. It has the potential to transform the legal sector. So blockchain provides an avenue of security as it's difficult to hack into. It cannot be altered internally. And this looks like a viable option for the push for digitization, as it may provide more security over citizens' rights. Rwanda have been considering blockchain technology after their digitization of services. There is the potential of using it to maintain public and land records. China have utilized blockchain technology in preserving evidence of a copyright claim, and the UK are looking at viable means of implementing blockchain technology to enhance efficiencies in their sectors. Now, blockchain technology has its limitations, which are well documented. For example, the high levels of energy required and the lack of understanding. However, as we explore this technology more and more, efficiencies are going to be created which limit and mitigate any of their harm. For example, in relation to how much energy it consumes, Ethereum has found a way of limiting the energy required by about 95.5%, which is a huge number. So this just shows over time, this is a technology that will become more viable and accessible. This is why it needs to be greatly understood by the Kenyan population as a new means of protecting data. Now, as a brief conclusion, the digital age has become ingrained in modern culture and has become the ultimate source of information and communication. It's provided innumerable benefits to economies and individuals around the world. Now, what we need to make sure is that states facilitate technological information and capitalize on its potential while mitigating the dangers they pose. It's not to say all ban this and ban that. No, we need to create a conducive environment for technological innovation in Kenya. Just as we did with M-Pesa, we need to provide the platform for us to pioneer Africa into the digital age. Yeah, that's my presentation on the digital age. Thank you.
Good afternoon, ladies and gentlemen. My name is Emma Oginga, and together with my colleague, Caleb Kipkoech, we were handling the topic, data protection laws and policies, the impact of AI on data protection laws and regulations. Now, due to time constraints, my colleague will do the presentations, and then soon thereafter, we will take questions.
Good evening.
My name is Kipkoech Caleb, and I was privileged to co-author the article with Emma Oginga. So we are so glad to present to you this evening. And much of the things have been discussed by my fellow presenters. And when actually you're the last presenter, you have to make use of the phrase a lot. Mine is just to echo what Mwalimu has said. But we are going to present. We are going to take a different perspective, and we are going to look at the impact of artificial intelligence on data protection laws and regulations in Kenya. So I would like to take you through an icebreaker. Imagine you've been employed in this international organization, or let's say a law firm, and over the week you had a very intensive debate or maybe a meeting, and you're required to prepare a report. And on Monday, because the people's president said that the demonstration have been called, and you've decided that demonstration will be held on Tuesday, and you're actually along Thika Road, you are doing your night concerts at 2 a.m., and then you remember that you have to do the report by Tuesday. And then your employer just texts you and tells you, I hope you are ready with the report. And now here comes the illustration. Because you have the ChatGPT logins, you are able to say no less, boss, I'm very ready for Tuesday. So I will not delve much into the legal framework on data protection because my colleague presenter Sophie Wanjala has already delved into it and given a very conclusive debate on it. So I'll just move on to the discussion on artificial intelligence and data protection. So just the illustration I was making, I was trying to make a point that in the digital world, there are different confliction between us enjoying the innovation, while at the same time we are trying to find a balance whereby our human rights, for example, the data privacy interests are being protected. So where do we draw the line? Now, it takes us to the discussion of artificial intelligence and data protection. So, there has been rapid growth of information and technology over the years. That is something we cannot dispute because the technologies that were being used in 1980 are not the same ones which are being used in 2022 and 2023, and the ones in 2023 will not be the same ones that will be used in 2030. So these has contributed to what is called information big bang. So what is really this information big bang? So information big bang is a situation whereby there are billions of smartphones and other gadgets that are able to collect, transmit, and store data and analyze it using increasingly powerful, sophisticated softwares. I can tell you for sure, our smartphones, our gadgets, they are very sophisticated in that they are fitted with some of the features which are able, with a command of a voice or a biometric or a facial recognition, they can be able to perform different functions. So with AI developments now, these trends are more likely to increase because with a different AI developing today, another gadget will come tomorrow. So the reason being is that most privacy sensitive data are powered by machine learning and decisions by algorithm. My friend presenter Merali has already dealt with algorithms, and we're going to deal and talk about the discriminatory features of these algorithms, the biases that really pose to an individual. So we are going to look at the searches, recommendation engines and tech networks and how they really affect an individual decision. So we have AI developments and evolution. They raise analytics of personal information to new levels of powers and sophistication. So this means that it signifies the ability to use personal information in ways which are more likely to intrude and affect privacy interests. Like I started by saying that we need to draw a line between as humans whose existence has been made easy, and at the same time, we want our privacy interests to be protected. So under the Constitution, under Article 31C and D, it provides a shield against use of any personal information in an unauthorized manner. So we had in 2019 the Parliament enacting the Data Protection Act number 24 of 2019 in order to give effect to the protection under this article. However, now we have already moved from 2019. What is the current debate considering the issue of artificial intelligence? So the current debate remains the limitation and failure of the artificial intelligence systems to effectively safeguard personal data. So that is the current debate that we are having. So AI has enabled the use of a vast amount of data, which could be sensitive personal information, because these are machines which have been powered to mimic human intelligence, to mimic human functioning. So it means that they are able to mimic even the use of personal information. They are created in a way that they're able to learn, to extract information, and to be able to use this information for their functioning. So the main contention here is that it brings a contention or a question of legal and ethical concerns on how we can establish and implement the user privacy while at the same time obtaining and processing data by individuals or companies that need to power artificial intelligence usage. So, for example, there are very many companies in the world which can't function without the use of AI. So now it raises a lot of legal and ethical concerns on how we can balance these interests. Remember, we are trying to bring the issue of harmonization of interest between the interest of the individual on this other hand, of data privacy interest, and the interest of the companies, because at the same time, we want these companies to be able to function in a way and also bring revenue to the economy. So we cannot just shut the company because it is using artificial intelligence, but we have to find a balance. So we have Section 26 of the Data Protection Act. As it was stated earlier on, it affords the data subject the rights to be informed of the use of their personal data. Furthermore, we have Section 35, which protect the data subject from being subjected to a decision solely based on automated processing. So automated processing is one of the major component and language of the AI because they function automatically. So our paper was really looking into the impact of AI, and we considered Section 35 because this is the section that is mostly affected when AI is applied. So therefore, the billion-dollar question still remain: how can the law on data protection be restructured to make a concerted effort to be clear about how AI will be processing data and for what purposes? So this is the limitation that AI suffers, because it does not explain to us how this data is really suffered, is really used, and how, for what purposes. So as we continue with the discussion, so most of the interest, they stem from technological advancement, as already alluded on. So it has also roots in the ability of computers to intrude into personal lives. So now we have to question ourselves, where is the information privacy here? So, and according to Alan Westin, he actually defined information privacy as being the claim of individuals to determine for themselves when, how, and to what extent information about them is communicated to others. So these are the major components which AI really lack, because you will just make a command and your information will just be used without you being realizing, or without you even realizing that you've already given consent. Because I can give you an example. Today, if you log into another different website, you will be told to maybe accept the terms or accept cookies. That is you giving consent to the website to access your information without you knowing. So we really need to have a discussion on the same. So there is also divergence of attention on what AI is capable of and what it can do and how it can do it. So these are downsides that we normally have oversights, and they can have a big impact on individual information and data collected in the process. So it actually poses a lot of implications due to its advancements. We already said that AI is more complicated because it mimics human intelligence and tries to go beyond it. So there was a study that was conducted by Stanford University. So the study was called the 100-year study on artificial intelligence. So the study was meant to inquire on the effects of regulating AI, and the panel concluded that AI enables computers that use algorithms to process large amounts of data and information, and to be able to draw and learn from the experience. However, the university also concluded that regulating AI can be catastrophic because they function differently on different platforms. So therefore, because of the advancement of this AI, data protection is an immediate discipline, which is immediately compromised because AI cannot function without data. So, yes, so let's have a discussion on the influence of AI automated decision-making systems. So, as already alluded on, AI, the major component of AI is actually, automated decision-making. So AI have also designated machines more responsibility, and the automated decision-making involves the use of data as an input, either to analyze within a process, a model, or an algorithm for learning or generating new models. So, however, there is a critique on these AI automated decision-making system because it lacks proper accountability in protection of human rights, because it really oversees the rights of a data subject, because your information will just be used in a way which is not authorized by you, and you as a data subject will not be informed on how your information has been used. The only thing that you will get is the result at the end. So therefore, despite the convenience brought by the AI, there is a presumed good that might also violate human rights. That is the conclusion that comes with it. So also we have Stan, who actually developed a 3D effect of artificial intelligence, and he actually expounded and said that AI is able to detect, determine, and develop. So those are the major components on how AI can really function with the use of personal data. So we have an example here. It's more what was discussed in the morning session. So the government has introduced video surveillance and biometric tracking to curb illegal activities, for example, terrorism. So this actually it's positive because it affords security to citizens, while at the same time it hinders criminal activities. However, there is a critic to it because they also monitor common citizens, and it can be able to track them, which is an infringement of personal privacy. So remember what Alan Westin was saying about information privacy, how much is communicated to others about us. So we can link this to Section 35 of the Data Protection Act, which really prohibits profiling, and there was when it comes to profiling, I'll just move to the next slide, which really gives a more detailed explanation on profiling. So as you can see on the slide, we have an article that was written on the New York Times on 14th April 2019. It was an article titled 1 month, 500,000 face scans, how China is using AI to profile a minority. So China actually received international condemnation because it was using this AI to profile and discriminate upon Muslims. So now you see AI here is bringing the downside of discrimination and also biasness. So here, the international community really condemned China on what it was doing at that time. And so we have already stated that AI automated decision making. It uses a variety of technologies, for example, algorithms which process a large amounts of data from different sources, database, text, and social media. So when we log in today to social media, a lot of things happen in social media and we don't understand. Today, you when you just log in, there's a feed that comes. You did not subscribe to the feed, but it just came. How? It's because of these algorithms that is able to detect something called behavioral patterns, like I'm going to explain in the next slide. So the illustration here is that algorithms are able to create what is called user profiles. So they are created and algorithms are not visible to the user, and it's not easy for you as a user to be able to opt out. So once you opt in, you're not able to opt out because this system is actually, it's more so function like a backdoor system. So for example, we have online retail markets, and I don't know if this is true, but this is true according to research and maybe practicability. But if you ever noted is that for example, let me use a very good example. We have Jumia and Killmall. Sometimes you just know, yes, today I don't have money. So you'll not get any notification for any marketing message. But when it's at the end month, is when you get a message telling you there are offers. So I usually ask myself how. But when you tend to think of it, it's more so of the algorithms that you're able to be created and user profiles. So in an online retail market, there is no need to enter into a specific market. So the smart algorithms, they're able to choose the best time to approach the consumer and make decisions on which offers the consumers will receive. So this means that the data is being able to be analyzed and enable the company to extract behavioral patterns of users and to predict emotional responses needed to make the user apt. So this is also the same thing that happens with TikTok, because most of the time there are algorithms that are created for you, a user profile that is created, and over time you will just be fed with a certain content, but you did not subscribe to the content. So the challenge that this poses is that consumers have no information or way of knowing about the profiles, profiles that are being built about them, and underlying method used to target and influence them. So there is also another article that was written last week on 30th March 2023. So this was written by Nicole Ellins and Tom McPhillips. It was why a ban on TikTok won't solve all data privacy concerns. So this article came as a result of the issue United States of America had with TikTok, and they were questioning the bipartisan agreements and also whether TikTok is a safe space for the U.S. citizens, because it was being it was alleged that TikTok is collecting and harvesting a lot of information about the user. So, and if you can follow the Senate proceedings, there are some questions that were being asked, which was so funny. For example, can TikTok use Wi-Fi? Can TikTok drain the battery? But those were really good questions because they tie up to the issue of data protection and all that. So as already alluded to, individual choices and ability to find information which he or she considers meaningful to make an informed decision is diminished. So the impact of this AI is that the independence of your decision is actually removed. You'll be just dependent on this AI to maybe get to a certain decision. So what then happens to the protection under Section 35, that is protection against automated decision making? So with AI, there is lack of transparency on how personal data has been analyzed. So we lack the explanation to what extent and by who and why they receive a specific content. We really lack that kind of explanation. What we just get is the end result, and we're able to enjoy the content or maybe consume the content that we've been provided for. So this really contributes to the abuse by artificial intelligence technologies in specific choice on how to expand data privacy. So when your choice has been taken, then you are not being able to really enjoy this data privacy. Yes. So furthermore, there is likelihood that a person might suffer social harm. For example, the one I was telling you, discrimination and biasness. So there was this case of Connecticut Fair Housing Center versus CoreLogic. So this was a case in the United States. So the court held that it was discriminatory to carry out involuntary screening program because this screening program allegedly collected a lot of personal information about a tenant, and it was being argued that it was against or it went against the provisions of the Fair Housing Act in the US. So individuals are also likely to suffer because algorithms that learn to collect information about what happens in an individual premises. For example, there are systems that we fit in our homes. For example, we have the Siri, Alexa, the Google systems which we use to play music in our homes. They have been held to be able to collect behavioral patterns. And when they do that, they produce something called targeting advertising and behavioral determination. And also, you'll find that in some of the jurisdiction, this has been used as one of the elements to determine credit worthiness of an individual. So you see, now there is an extent of information about an individual being used to discriminate them on the aspect of credit worthiness. So furthermore, what then? I'll not delve into the data subject rights because my colleague Wanjala has already dealt into it. But what you need to know is that artificial intelligence incorporates machine learning, big data analytics, algorithms, and among others. And these are the ones that are more likely to infringe on data subject rights. So, however, there is a question that is raised on the hidden systems that are used by these technologies and the veil that is not easy for a data subject to lift and be able to see how their data has been used. So there's an issue of disclosure of information. So thus, my question is, where is the line between advantages that are offered by these AI technologies and the extent of threat towards personal data and information? So when you look at Article 27, it offers discrimination. It offers a protection against discrimination, including algorithms. So, however, we can say that it is faced with several inadequacies in its operation because Data Protection Act does not really address the issue of the new trends that are going on in the current AI sphere. So you find that as much as we have the general rule under Article 27, there are some inconsistencies and also some inadequacies that are not provided for under the Data Protection Act. So therefore, it is difficult to establish the issue of direct discrimination by these AI algorithms. So an illustration here is what has been happening in Kenya for a very long period of time. So we have the Ministry of Education, which is now using an automated computer system to form for Form 1 selection. So you remember Form 1 selection and placement. You remember when you were joining Form 1, you just being told that you've been placed in a certain school and maybe you did not choose the school. So there was that issue that arose over time. So, however, the ministry was arguing that its systems is premised on the principle of merit, equity, and choice, as well as the capacity and category of schools. However, when it was taken to court in the case of John Kabui Mwai and 3 others, and versus Kenya National Education Council and 2 others, the court was able to note that the declared government policy in national schools admission is not based exclusively on merit, but it should be also based on equity and fairness. So the court was trying to say that as much as you are using an automated system, ensure that there is merit on equity and fairness. So another instance that arose last year. Last year, I'm not sure about this, but it was the issue of political parties registering members fraudulently. You remember there was a time people took to Twitter and they were arguing that they have been registered to different political parties which they didn't even belong to. So this was a question of automated decision making that really raised concerns and eyebrows in Kenya. So in concluding our presentation, there are different findings that we noted when we were doing this research. The first one is that we identify the challenge to data subject rights has also been identified in the paper. For example, the use of AI really, infringe on data protection rights. So this is an area that really need to be addressed. So another thing is that AI being one of the emerging new trends, the Data Protection Act of 2019 can be argued as being non-conclusive and in its protection. So there are many inadequacies and lacunas that really need to be filled. So there is need to develop algorithm systems in such a way that they enable auditing and accountability. So most of these AI, they really lack auditing and accountability. So we need to have an algorithm system on where we can know how our data is being used and processed. So furthermore, the law should also impose a requirement for interpretation of algorithm systems to enable an individual understand what they are getting into. Because today, if you log into a website, you're not able to know how your information is going to be used, or you're not able to know how you gave your consent for your information to be used. In concluding, we had some recommendations that can help in ensuring that the Kenyan legal context on AI can be protected, and also ensuring that there's data protection and balancing between innovation and us enjoying our rights. So in the concluding statement is that the study revealed that protection of individual data should be a priority in the dynamic digital age. On this basis, there is need for an examination on different aspects that surround data protection, laws and principles. So the first one is that Parliament should enact rules on data collection and sharing. So the data protection officers should be put in place. So we should have these rules, because as much as most of these AI systems allegedly have inbuilt privacy systems, we need to have privacy officers who are able to exercise an oversight on these systems to ensure that personal data is being used in the correct manner. So thank you so much for listening to us. I wish to yield the floor back to.
Wow. That is a lot to take in from all the 4 presentations that we have had. It is very new information. Honestly, I just know 3D movies and Meta being Facebook, but Metaverse, I think I'm interacting with it for the first time here. So we are all learning, and I am sure that all of you have been able to, something has been triggered in your mind. And should we have any questions now, this is where we can ask those questions and seek clarifications on various issues regarding all the presentations that have been made this afternoon. So yeah, so we can start from there.
Good afternoon, esteemed ladies and gentlemen. My name is Elizabeth Mboya, and I have various questions and concerns. To start off, in our mid-morning session, we were holding back on digitalization of our services and just really moving into the digital age, which we actually are in, citing various challenges. But right now, we are talking about artificial intelligence. We are talking about the metaverse. We are talking about the digital age and data protection. With that foregoing assertion, we have had various industrial revolutions. This is the fourth one, and it is a knowledge based industrial revolution with technology and AI being at the pinnacle of it all. So I am opining that rather than us holding back towards digitalization, we should actually embrace it because this is the future and the future is actually now. So my next part will be questions. And my first question is to Miss Elizabeth. You talked on intellectual property in the metaverse. And I really loved the discussion. And I wanted to bring to fore the fact that we have actually had the metaverse. And because we are actually experiencing it, there are a lot of transactions that are going on in that space. But there are no laws to actually regulate that particular space because we have now moved from our actual reality and we are experiencing the world through virtual reality and augmented reality headsets. So, with that being the case, people are actually infringing IP rights in the metaverse. People are actually evading their obligations and bankruptcy orders in the metaverse by using the cryptocurrency wallets and the yes, of the blockchain technology to actually transact using cryptocurrency and just evade their obligations in bankruptcy. Moreover, the copyright issues that non-fungible tokens raise is actually a great concern because right now we are having the copyright amendment bill. And I really think that the fact that law has always been trying to catch up with technology, we should actually incorporate non-fungible tokens because they're actually what is that called? They're actually art in the digital space and which should actually just be covered in the copyright laws. My next question is to Miss Sonia. You talked about data protection, data surveillance, and that topic was actually very informative. But I feel that there is a disconnect between the cultural and social norms in our current society to the existing legal framework on data protection, because although the Constitution in Article 31 protects the right to privacy, which actually is the mother of data protection, and various international conventions like the ICCPR protect data protection and the right to privacy, our social and cultural norms state otherwise, in the sense that nowadays everybody just wants to take a video, a picture. You might be there chilled, minding your own business, whilst I'm minding your business, taking a video of you. Next, you know, you are a meme or you are GIF, and it's crazy. So, how can we strike a balance between the cultural and social norms? Because they're actually existing legislation on data protection, though it actually needs 1 or 2 tweaks to be up to date. But there are so many infringement on privacy, both from public institutions and even us generally as private citizens. So really, how do we strike that balance, or is privacy just an illusion? My third question is to Mr. Asgar. You talked on law. I'm sorry. You talked on law in the digital age. I took that to also include academia because I'm really an enthusiast. So, apart from ChatGPT, we actually now have Chat PDF. And with Chat PDF, you can upload any document and it will be able to translate it and traverse it to you. So, how are we able to protect the integrity of academia vis-a-vis enjoying chat GPT, chat PDF, so that they don't actually contravene copyright issues and the issues generally, because education shouldn't just be about regurgitating stuff. We should be trying to actually formulate new policies and just come up with better ways of handling and bettering our society. Thank you so much. Be blessed.
Thank you. Any other questions?
Good evening. My question goes to Miss Elizabeth. You spoke about when one buys an NFT, they get a license and not the copyright. So how does that process work, and how me as a buyer will I be protected from fraudsters? How does that work? Yeah.
Hello, my question is addressed to Elizabeth as well. You talked about some movies. I wanted to ask about Free Guy, a movie, whether it's based on the metaverse as well. And if it's not, you can just give us an explanation as to why it's not.
I have a question. My question is to Ms. Sophie. When you spoke about the rights of data subjects, you mentioned deletion and correction. Most of us have WhatsApp, and some of us have something called GB WhatsApp. With that one, when I send you a message, a risky message, and then I delete it, you still get to see it, even though I have deleted it. So that feels like an abortion of the law. What do you think about that?
Good evening. I have two questions. My first question will be directed to Caleb and Emma. So, why is it difficult for people to opt for better search engines? For example, DuckDuckGo, whereby somebody can conduct their searches safely without being tracked or having to leave their data back online, as opposed to using maybe Google, where the data will be in the open and everyone can access their data, or maybe they will be given a lot of cookies that will make them really vulnerable in the internet space. So why is it difficult for people to opt for such better search engines? And my other question is to ask her. So my question is on cyber crimes. My question is on cyber crimes. You realize that in most cases, there is a lot of cyberbullying, especially on Twitter. So why is it difficult for people to bring such cases? Yeah, in as much as every other day you'll see that there's a lot of cyberbullying on Twitter, and to the extent that Kenyans on Twitter actually made the immediate former president leave Twitter. So why is it so difficult for people to come up with cases and make sure that they launch complaints on cyberbullying cases? Thank you.
I believe if there are no other questions, I will invite our presenters to come. You have a question? Okay.
For Caleb and Ms. Oginga, just as you address the questions from the audience, I would also like to hear your opinions about the robot lawyer in the US. There is an element of privacy and confidentiality when a lawyer is talking to their clients. You've heard what has been happening recently, even in the media. A lawyer is summoned, the lawyer and the LSK is saying, no, the information that the lawyer has is confidential. The lawyer is not supposed to disclose that information. So I don't know exactly how a robot lawyer deals with that aspect of client advocate confidentiality. Perhaps you could a little bit talk about that.
So we can start with Aska. And while you're answering your questions, when you're done answering the questions, you can also be giving your closing remarks.
I'll start with the plagiarism. I think that's the overall theme of the academia, yeah? So I think it's just like anything else we use for referencing and things like that. I think we just have to make sure you go to the original source. You have to remember when you're using these platforms and all these things, you can genuinely ask them, where do you get this source from? And they'll tell you, and you can ask, provide me a link for that source, and it'll provide you a link for that source. So I think what you need to do is just go back to the original source and make sure you're not plagiarizing any work. I think what you should try to look at these platforms as is like Google on steroids, provides you more information, and you just have to make sure that whatever you're referencing, you refer back to the original source material. And then for Anastasia's question, I think it was on cyberbullying. I think the key issue with cyberbullying, especially on social media platforms, is number one, accountability, and number two, enforceability. I think just finding specific accounts, you have to locate the IP address and all these things. You need adequate enforcement agencies. Countries like Kenya, we don't really have that. When you'll see like discriminatory remarks online, the West is trying to clamp down more on it, especially when you look at sports. You look at footballers who are racially abused. They have agencies now that can enforce certain mechanisms in making sure they'll track down the IP, they'll DDoS them, which is shutting down their internet access, and then they'll send police to the house. We don't really have that infrastructure given we can't even log into our DSASA most of the time. So we're still a ways away. But the key issue is anonymity on social media. You can create a new platform, a new account with a picture of a footballer and call yourself David. Your name is probably something as far away from David, but we can't really know because accountability is next to impossible. So I think as technology develops, maybe they'll have tools of identifying IP addresses and sending it to the relevant authorities and then reporting you for anything discriminatory. Yeah, I hope I've answered your questions. I tried to make my presentation as brief as possible because the paper is about 10,000 words. So it's a lot of information to try and regurgitate. Yeah, so there's other aspects that's like cyberbullying I've tried to speak about that, but yeah, hopefully I've answered your questions. Thank you.
Yeah, so thank you for your interventions on the issue of the metaverse. What I can say, particularly to do with copyright, and there was a case that I didn't mention. So there was the Roblox platform. So there were the avatars, they have like cylindrical heads and the bodies. There's a company in Hong Kong called Huawei that actually copied those avatars and made real life dolls called avatars. That case is still in court, but it's important because it will give us a direction on whether if somebody creates something on the metaverse, you as a normal person, can you now take that thing and make a real version of it in Kenya and be okay? Will somebody sue you because you've seen something in the metaverse that somebody else created? How far will intellectual property stretch into creations that are done within the metaverse? Yeah. And also just to chime in on the issue of ChatGPT, because I think most people mentioned it. My colleagues and I at Aga Khan wrote a paper, and it's discussing the ethics of using text generating software. And so I think we mentioned in the morning that in copyright law, an author has to be human. And because AI is not human, it doesn't own any copyright. So when it's giving you all those responses, it's not the author. And when you're using all those responses, because you didn't write it, it wrote it for you. You're not the author. So where does that work fall into? Who's the copyright owner? We proposed that perhaps the AI can be a ghost author, because ghost authors are hired to be in the background to do all the work, and then somebody else take credit, but it still falls under plagiarism. So under copyright law, that work doesn't really belong to anyone, and it will be interesting to see how we reconnect ownership issues on AI generated works. It's still not very clear. On the question about NFTs, how do you protect yourself? So when you buy an NFT, there is something called a smart contract that's generated, okay? Everything that is attached to that work is within that smart contract. So your work is secure. You just have to make sure that you lock your wallet. Your crypto wallet is where you keep your NFTs. If somebody gets access to that, then they can essentially take your NFTs. So in terms of buying and the whole process and the whole transaction, that's a very secure process, because it's all in the blockchain, and the blockchain is a secure way of ensuring that your work is safe. Free Guy was not a movie about about the metaverse. It was actually about a character in a game who went out of character because he was an AI. And in essence, it's saying in some games, some AI can just develop at a pace and then go outside the code and become something else. So no, that wasn't about. Maybe you can try Ready Player One, which perhaps was more metaverse-ish if you want to watch it.
Okay, to Elizabeth, on your question about misuse of personal data and the law that has now been enacted. When in law school, there's a unit called jurisprudence. Jurisprudence is about someone's reasoning. For example, we talk about jurisprudence coming from a decided court case. Like what has been said. Like you can read a judge's decision or a magistrate's decision, and then you know exactly how the judge will, not exactly, but you will get you'll get some foot, and you say, if I go before Honorable Lenaola with this argument, he will not bite. So what happens is, when you're studying jurisprudence, sometimes there is you study about the law following social change. Like a lot has been happening in our social cycles. So the administration or the government decides, let's regulate it. Let's put a law to this. That means things change socially. So there's a law to regulate it. The law followed the social change. The social change came first, and then there was a law. But again, there are some other situations where social change now comes to this side. Social change comes to the law. You get, there's the social the law, they follow the social change, or the social change follows the law. So that if people are killing each other aimlessly, we are used to that. But then the law comes in and says, no, let us regulate that. So it just depends. Sometimes the law follows social change, what has been happening, and people who sit down, they also reason. They say, this has been happening and it is rational. Let us regulate it. Let's make it legal anyway. Or this has been happening and it cannot continue to happen. So let's put some safeguards. So there's a balance. There's a balance to be maintained. And these things, they do not happen at once. You go step by step. Even right now with the Data Protection Act in place, people are still misusing information. People are still sharing information anyhowly because they have not yet understood the full impact of data protection law. But the moment they will understand, we will see what will happen. Cases will be decided, people will be paying fines, people will be going to jail, and then now people will understand, oh, let's wake up. The Data Protection Act has taken course. Let's be very careful. On the deletion or correction of data, that gentleman asked, yes, it exists. But you see, once you delete some data, there is something you are trying to do or not to do. Now, Elizabeth just talked about some research they did with a friend. I think it will be very interesting to follow up about the computer-generated softwares, the ones that undo now. So they are plowing, but I mean they're undoing the law. The law says it does not exist, and then there's a computer-generated software which undoes it. But sometimes you have to look at why is someone looking at undoing or reviving the chat which I deleted? Are they trying to prove something which is legal? Are they trying to set you up for something illegal so that you can be arrested or something so that you can be implicated? So it's a delicate balance. We look at the justification. Why does the person want to revive the information that you have deleted, you're not interested in, you do not want it to be seen, which is your right, by the way, but maybe you are trying to compare it, you are trying to balance it with somebody else's rights. That's now when the computer-generated software, they come in. I think it would be interesting to follow up with Elizabeth to know how they deal with that, the computer-generated softwares. But on my closing remarks, you remember when I started my presentation, I asked Catherine how many children she has. I asked her what is his bank balance. And they both told me without any sweat. That means we are not appreciating our privacy. Because I expected Aska to say, why do you want to know my bank balance? I expected Catherine to say, why are you interested in my children? But no, we are not appreciating that sometimes we are trying to set ourselves up. When you're posting your children on social media, okay, it's not bad, but this is my opinion. When you're posting your children on social media, you are updating everybody where you are. You are telling everybody your job, your salary, this is my house, this is my car. The generation we are living in right now, social media is bad. It is very bad. So Catherine has a bank balance of $500,000 and she is not paying my 10,000. They don't even go to the authorities. They come for you directly. So I think it is important that going forward, you appreciate that there is some data about you that not everybody needs to know, just you. And if someone wants to know their data, someone wants to know information about you, it's important that they provide a justification for the same. Why do I want to know the number of children that you have? Why would I want to know where Elizabeth stays? For what? So once you know that, you will help the authorities to protect yourself. The law is there, but the law cannot be policing you 24/7. If I intend to harm you and I don't know where you are, I simply cannot do it. But you have posted on social media that you are in Naivasha at the Safari Rally. That's where I'll come. I want to abduct, or is it kidnap, your children. I know where they school, I know the uniform, I know their faces, I know their names. I'll simply go to school. I say, I'm aunt or I'm a friend, the mother is injured. Give me the kids, I want to take the kids home. And I disappear with the kids. So you set yourself up. So a clear understanding of the Data Protection Act and specifically privacy, it will give you that understanding and that exposure that privacy is really very important. And sometimes once you lose it, you cannot get it back. So, and something else, the very last one that I forgot to mention in my presentation is about third parties. Somebody asked about third parties in the second session of this session. I mean, after the tea break, someone asked about third parties, and they said, you want to file a case, and then they tell you, go and pay some amount at KCB. Yet they don't have a contract with KCB. So KCB in this case is a third party. And a third party, they work with the data controller, the person who has your data, so that they can perform a contract in your benefit.
so that when you want to file a case, the judiciary is not a bank, but you need to pay the fees. So KCB has to come in. The only question is, will KCB keep my data? Are they under obligation to keep my data the way the judiciary is, for example, the judiciary being the data controller? So the element of third parties brings in a bit of a challenge because the data controller, so I can give a good example of National Employment Authority. If you go to National Employment Authority and say, I do not have a job, I'm looking for a job, they keep that information in the database. When something comes up, they call you. Now, this is just an example. But now you do not have a direct, there is some information that the government has that is about you, and National Employment Authority, they need that information, for example. So the government will have to give that information to National Employment Authority. But now the question is, are they going to keep the secrecy the way the government has been keeping that information? So I think that it's an ongoing discussion. And since this law is relatively new to the continent, so I think we are going to see changes in law, enacting of other laws, so that there can be better collaboration among the, even locally and among the countries. Thank you.
Good afternoon, everyone. So I would like to answer the question posed by Ms. Wanjala on the ability of a robot lawyer or an AI attorney to be able to maintain advocate-client confidentiality and privacy. So we have to acknowledge that AI, with regards to lawyering and advocacy, is still an upcoming area. It has not been fully developed. But my understanding of how it works is that the attorney or the AI attorney goes to the court, is able to listen to the proceedings and process them, because basically this is a computer. Yes, processes them, and is after processing the information, it comes up with arguments, and then it transfers to now the natural person who is a lawyer to be able to communicate to the court. That is how it works. This means that as a client, you don't go directly and speak to the robot spilling out your issues and all that. You're getting me? Yes. So as far as privacy and confidentiality of the client is concerned, that is maintained. Maybe a gap that could be raised with regards to an AI attorney is when it comes to the ability of a lawyer to exercise independent judgment when it comes to the profession. And we've heard there have been arguments, there have been discussions on whether a robot is actually a qualified lawyer, and it is something that is still ongoing. It has not been concluded. Yes.
Thank you. I would like also to answer the question posed by Anastasia on opting out of the cookies and all that. Over time, Google has been sued for privacy concerns. And nowadays, I believe you can be able to opt out of the cookies, because at the far right, there is the three dots whereby you just click and then you go to settings and then you delete the cookies. So you'll be able to delete the cookies. However, there are some of the applications whereby they give you only the option of clearing searches, but they are not able to allow you to see how your information is being used. The reason being is that the argument that they propagate is that they will be infringing their own IP rights, and at the same time they'll be spilling their trade secrets. So they're trying to hide behind that veil while they're denying us to know the algorithms that they are being used to process your information. Recently, there was Twitter, which released the algorithms that they use to process information, and that is now what is being embraced in the new digital world. So, but there are some applications whereby you cannot easily go behind their veil to be able to see how the algorithms function. And also on the issue of robotic lawyers, I'm also of the argument that just to add what Emma said is that a robot is basically like a computer. I also try to believe that the owner of the IP is the one who is mandated to ensure that confidentiality has been upheld. But now this is a new area that really needs a lot of discussion because, as my colleague has already stated, there were arguments that this robot lawyer has not gone to law school, hasn't done by exams, and hasn't been admitted. So now, why should we allow the robot now to practice in a court of law, yet they don't have the qualifications? So this is a gray area that really need to be looked into, policies to address the situation and really see how advocate client confidentiality can be upheld. Yes, thank you.
We need to give a heavy round of applause for all our presenters for a job well done. We have learned, we have benefited so much from them. And I'm also seeing the comments from the online participants, and they are happy and they appreciate the information that they've been able to learn today. So this marks the end of our day one. We are happy and we appreciate your participation, and we hope that you will join us again tomorrow to continue this conversation of law in the digital age. And tomorrow we'll be looking at human rights. How does technology and law affect your rights as an individual? And also we'll be looking at how the legal education has been affected or will be affected by technology. So we hope to see you tomorrow, bright and early, so that we can continue having these discussions and this conversation. And maybe, who knows, out of this, we will have policies that will be of benefit and will fill those gaps that we have been able to identify. We also want to invite you for tea at the same place where we had tea this morning. So we'll just walk out to go down, and right in front there, we'll be able to have our tea. I think that's it for today. So we are free to leave.
Presentation yao.